Hafa Day. Thank you all for being here today. The Committee on Health, Tourism, Historic Preservation, Land and Justice is now called to order. Today's Wednesday, January 15, 2020, and the time is about 1:04 p.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Monday, January 6 and Monday, January 13, 2020. Notice was also published in the Guam Daily Post on Wednesday, January 8th and Monday, January 13, 2020. I'd like to thank my colleagues for being here today, beginning with our Legislative Secretary, Amanda Shelton. Thank you for being here. Senator Kelly Marsh Taitano, Senator Jim Moylan, thank you for being here, and Senator Luis Borja Muña, thank you for being here, and Senator Terlaje Dusmasi. We have several agenda items for this hearing today. 6 bills. So I'm grouping the first 4 bills together because they deal with minimum and maximum sentences for different criminal conduct. And those 4 agenda items, the first 4 agenda items are bills number 96-35, Bill 125-35, Bill 97-35, and Bill 143-35. So each of these bills will be more in detail introduced by the sponsors of the bill, but all of them are relative to minimum sentences in different crimes, or the sentencing of different crimes. The remaining 2 agenda items for this afternoon will be Bill 98 and Bill 160. Bill 98 is relative to penalties associated with crimes against tourists, and Bill 160 is relative to pretrial releases for those charged with crimes associated with criminal sexual conduct, robbery, kidnapping, and distribution or possession of controlled substances and mandated electronic devices for bail conditions of certain crimes. I'd also like to acknowledge the presence of Senator Mary Camacho Torres. Thank you, Senator. All right, and so as I said earlier, the first 4 bills on today's agenda are relative to increasing the minimum and maximum sentencing of crimes of criminal sexual conduct, robbery, arson, criminal mischief. The committee notes that for many of these crimes, minimum and maximum sentences already exist, including life sentences for some of these crimes, and these are all subject to judicial discretion. They are also subject to sentencing enhancements and exceptions that exist in Guam law. So where we have minimum and maximums, we also have Okay, I misplaced that. I'll have to read it later, but we also have provisions of law that make an exception for first-time offenders to the sentencing that's outlined in the statute, and we have provisions that would enhance sentences based on repeat offenders, habitual offenders, vulnerable victims, and other statutes that also change the penalties, and hopefully we can have the Attorney General, Public Defender to clarify these points. But in preparation for this hearing, the committee requested the guidance of the Attorney General of Guam, the Judiciary of Guam, the Public Defender, as to the continued desirability of judicial discretion in sentencing and whether the proposed sentences would deter crime or are equitable and fair, as well as the potential impact of these bills on prison overcrowding. Guidance from these entities is vital to the discussion of these bills and is forthcoming. We also sought guidance from the American Bar Association, which has published its position on mandatory minimum sentences. And if I could just read this very quickly. The ABA, American Bar Association, has urged the U.S. Sentencing Commission on August 7 to include in its 2019 priorities proposals to address the impact of mandatory minimum sentences and to study whether current guidelines effectively encourage the use of compassionate release, when, quote, extraordinary and compelling reasons, unquote, exist. In comments submitted to the Sentencing Commission's acting chair, ABA Governmental Affairs Director emphasized the ABA's lengthy, quote, lengthy and robust opposition to mandatory minimum sentences dating back 50 years, unquote. ABA policy adopted in 2017 reinforced the ABA's position, pointing out that such sentences, according to the report accompanying the policy, are, quote, detrimental to society because they lead to excessive sentences, result in sentencing disparities, undermine the discretion of the judiciary, and punish minority defendants disproportionately, unquote. Sussman also outlined the ABA's longstanding support for development of standards for reduction or modification of sentences based on exceptional circumstances, including but not limited to old age, disability, changes in the law, exigent family circumstances, heroic acts, or extraordinary suffering. The association also urged the Commission to promulgate policy guidance for sentencing courts and the Bureau of Prisons to use when considering reduction of sentences. And of course, we're all here because we are concerned about crime in our island, in our villages. And so we're trying to find a balance of this between, removing discretion in sentencing and imposing maximum or minimum sentences, and or whether even increasing the sentences will deter this crime or protect our villagers more. So that's what we are hoping to find the answers to today. And we will begin with the first bill on the agenda, and I'd like to ask the sponsor to introduce the bill, but if I could first also acknowledge the presence of Senator Clint Rigel. Thank you, Senator, for being here. So Senator Jim Moylan, please proceed on bill number 96-35.
Thank you, Madam Chair. Bill 9635 is an act to amend subsection 2515, 2520, 2525, and 2530, all of Chapter 25, Title 9, Guam Code annotated, relative to the minimum sentencing of first, second, third, and fourth degree criminal sexual conduct. Bill 9635 would increase the minimum sentencing of those convicted of first, second, or third degree criminal sexual conduct from 15 years to 25, and establishes that anyone convicted of a fourth degree criminal sexual conduct would serve a minimum of 15 years. The current law establishes that a first-time offender may be convicted as a misdemeanor. Bill 9635, we understand that one too many times we see a defendant charged with a first or second degree charge of criminal sexual conduct and then plead down to third or fourth charge. Hence, the penalties could result in several months in prison, inclusive of time served. This legislation, just as the others we will discuss today, are to present a strong message to perpetrators when it comes to serious crimes such as criminal sexual conduct, that enough is enough. Some may say that these penalties are too excessive, or that our prisons are overfilling, or even that they may not benefit those who can't afford a top-notch attorney. The reality is that as a government, this is not the response we can give those victims, especially children. We hope to generate a healthy dialogue on these issues today. I look forward to the presentations, and thank you, Madam Chair.
Thank you very much, Senator Moylan. I'd also like to note for the record that in addition to those noted earlier, we also have requested the feedback for this bill from the Guam Police Department, Child Protective Services, victims advocates reaching out, the Guam Coalition Against Sexual Assault, and the Guam Bar Association, and of course the public. So now we will accept testimony from anyone who wishes to provide testimony on this particular bill, number 96. Former Senator Chief Ishizaki, you may proceed.
Madam Chair, Senators, thank you for allowing me to speak before you. You know, I think we need to be tough on crime, and I think we deserve a safe community, certainly. But I'm going to also caution you that when people get convicted of crimes, you know, the pretrial detention and then post-conviction confinement, Department of Corrections, and I speak for the Department of Corrections, we're overloaded, we're overcrowded. So if you want to impose stricter sentences, I think you got to keep in mind that there is no room at the inn, and that we risk getting into another consent decree with the federal government. And I think I'd like to invite all of you to come tour the department and see how crowded it is. I have cells in Hagatna, for instance, where we have 7 or 8 people in a cell. It's not humane. You know, so to me, it's like we have to balance the need for justice and safety and security and protecting our children. I cannot argue against that. At the same time, we've become a warehouse for offenders. And I would like to suggest that we think about treatment. We're not doing treatment. We are sorely lacking in treatment. Over the past several years, in order to cut spending, the Department of Correction was severely shortcutted in its appropriations. And the end result of a shortage of appropriation is we have fewer officers today. And the negative impact was also that we've reduced treatment. You know, the psychologists, the caseworkers, the drug treatment people, the numbers have dwindled. So we're not able to prepare our convicts for success when they are released from prison. And I just implore you to please help us figure out, beyond just incarceration, is more treatment and being smarter with incarceration. And you got so many bills to hear today, and I think I'm going to echo the same thing over and over and over again. And I just ask for balance. We need balance. In the whole criminal justice system, for instance, for the police department, the governor's on a heavy move to hire more police officers. And that's good. But the end result is more cops means more arrests. And then, you know, as lawyers, you're going to also see the impact on the prosecution and the judicial system, because it filters into the whole criminal justice process. And in the end, many of these people end up in the Department of Corrections. We are overpacked, seriously overcrowded. And so I think I'd like a more informal discussion on how to find balance. I thank you.
Thank you, Senator Ishizaki. On this bill, is there anyone else who wishes to provide testimony on bill number 96-35? If not, then we will, okay. Please state your name for the record. Wait, you're going to need to turn on the microphone? Yeah, and you may be seated.
Thank you.
Thank
My
you.
name's John Morrison. I'm the Deputy Director of the...
I'm sorry, can you repeat that? I can't hear you very well. Just
right.
do it again. Into the microphone, yeah. Thank you.
How's this? Senators, my name's John Morrison. I'm the Deputy Director of the Public Defender Service Corporation. Our director, Steve Hattori, couldn't be here today, but he provided some written statements for the committee that I would read at this time, if that's permitted.
Please do.
Very
On
well.
bill number 96?
That's correct.
Thank you.
Senators, Bill 9635 seeks to, 1, greatly increase the mandatory minimum terms for imprisonment, 2, broaden the definition of coercion, 3, creates a new level of felonies, specifically fourth-degree felonies, eliminates fourth-degree criminal sexual conduct as a felony. Before an analysis of these proposed changes, the legislature should be made aware of the current state of criminal sexual conduct cases within the island. The first premise of the bill is that criminal sexual conduct cases are on the rise. A look at the Uniform Crime Report and the most recent Guam Police Department Citizen-Centric Report seems to contradict that claim. According to the 2017 Uniform Crime Report, the incident of reported rates were as follows. In 2013, 106. In 2014, 118. 2015, 160, 2016, 103, 2017, 32. According to the 2018 Citizen-Centric Report from the Guam Police Department, in 2018, there were 61 reported cases. 2019 numbers are currently unavailable. Nonetheless, the statistics do not show an alarming increase in criminal sexual conduct cases. Also absent are relevant evidence-based studies which demonstrate the need for a mandatory minimum sentence, 25 years for first, second, and third degree criminal sexual conduct, and 15 for fourth degree criminal sexual conduct. There's no evidence indicating that there is a high risk of recidivism among that target population. Secondly, additional punishment is not necessary. Currently, if you're convicted of first-degree criminal sexual conduct, one could receive a sentence of 15 years to life without the possibility of parole. None of those 15 years can be suspended. A repeat offender faces a mandatory minimum sentence of 25 years to life without parole. For a second-degree criminal sexual conduct charge, one that only requires touching, the sentence is currently 5 to 25 years. A repeat offender may receive a minimum sentence of 25 years to life without parole. One convicted of third-degree criminal sexual conduct faces a jail term of 3 to 10 years for a first offense. These sentences are among the harshest on the books. If the victim is 13 or under, or 55 years or older, 9 GCA 8037-3 creates a vulnerable victim enhancement that could add 5 to 25 years on top of their primary sentence. The mandatory minimum sentence for sex crimes is already sufficiently harsh. In fact, it's been Director Hattori's experience that clients charged with criminal sexual conduct consistently receive tougher sentences after trial than ones charged with homicide or other violent felonies. A mandatory minimum sentence is not necessary to protect the public because generally the judges will impose a long sentence already permitted under the law. A mandatory minimum makes it difficult for the marginal cases, the ones with little to no evidence, just the words of a convincing victim. There are many reasons a case charged out as first degree gets reduced with a plea agreement to a far less offense. One of the reasons is because of the mandatory minimums. Oftentimes, a victim wants to avoid the trauma of confronting their perpetrator in court in front of a judge and jury and now the media. This is going to echo throughout, but Director Hattori makes the point that judges are judges for a reason. They've been appointed by the governor, confirmed by the legislature to make tough decisions. Mandatory minimums restrict the discretion of our wise judges. There are many mitigating factors a trial judge should be able to rely on in fashioning a just sentence. Preventing the exercise of this discretion has resulted in the resolution of matters that are both contrary to the fair administration of justice and individual rights of victims. Director Hattori in this testimony goes on to make some examples. I'm going to submit that for the legislature's consideration in more detail. I would echo some of what Senator Director Ishizaki said when he referenced the need for programs. We think those are desperate. We're desperately in need of those, I believe. There's a lack of adequate sex offender treatment on island. I think that's something that everyone knows. I think that is something that would better address the issue that the legislature is faced with here, as well as the need for drug treatment programs. Those are my comments as to that bill.
Thank you very much, Attorney Morrison. Are there any questions from the panel? Oh, can we get a copy of that? Can my staff get a copy of the testimony from the public defender on bill number 96 right now? Pass it to the panel. And so questions, Senator Moylan? Senator Marsh-Titano?
Again, thank you, Madam Chair, and Sejuis Masi, everybody, for being here. It's important to hear the testimony from hopefully as broad a part of our community as possible. But of course, certainly it's very important to hear from our key stakeholders. Our key stakeholders. So I have some of these questions, and before I start, it had been pointed out that some of the legislative intent that there is contradiction in the actual statistics themselves and our reporting of those statistics. And I want to point out, because it shows up in several of these bills, that I went to the National Bureau of Economic Research and I read the section there. And so what is listed here as simply summarizing is incorrect. It's a citation from a particular study that applies particularly to California and particularly from studying Proposition 8, which is particularly, to use that word a lot, is particularly looking at enhanced sentencing for repeat offenders. So I do not believe it can be applied in a blanket way as it is in these several bills, and it's presented in that way. So I just want to clarify that's problematic right there, because to use it as justification for a lot of things in these bills becomes very problematic. It's very specific to very probably specific conditions of California and so forth, and it would take a whole lot more analysis, I would think, before it's applied in a blanket way. One of the questions that I do have, and perhaps the Office of the Public Defender can explain this to me. And so, first of all, I just want to mention that these sort of bills are very important to go through. We all care about public safety. We all care about making the island safer, doing the right thing, and certainly protecting our people. They are especially difficult for me because I have lived through some of these things and they become very emotional. But in analyzing them, that's the important part. So my first question is, why is it that there is this difference of treating 12 versus 14 versus the age between 14 and 16? I want to know if there's science behind it. I want to know if there's anything particular data-driven on Guam behind it. My thinking is in a lot of these bills, we have our consent age of 16, that anything below that is a minor. So I'd like to know what the reasoning is, or if this is just maybe has been in the books for a while, and maybe it's something we need to consider updating. If you know of any of the differences between those distinct ages, 12, 14, between 14 and 16?
I think, thank you for that question, Senator. I don't have personal knowledge of what was on the legislature's mind when they passed that original bill. However, I would say that there was a period of time where legislatures throughout the country were adopting similar legislation, and I think this is probably part of how that was adopted. I believe it became more or less an industry standard for a period of time. I'm not sure in other jurisdictions if they've reconsidered some of those previous pieces of legislation.
So Juice Masi for that insight, and for me, I can see a lot of justification for just having the category of anybody under the age of consent, because these can be horrific situations that will stick with people forever, and it doesn't matter in what I've ever read and studied or experienced, 15, 14, 13, 12, 9, 7, it's all very traumatic and should be treated as equally reprehensible. So I would say that, but thank you very much. These
Senator,
things do change over time, and so I think it's good to hear that maybe this was the thinking of the day, and maybe it's time that we revisit that. Yes?
I would like to add one further comment that, from my office's perspective, there is a distinction to be made there, and that's that it may well be possible, particularly years ago, to consider a situation where a 15-year-old may have been in a relationship with an 18-year-old, and the family may well have known about it, but that certainly would never apply in a situation where the person was 12. or younger. So I think there is a distinction to be made from our perspective.
And that would maybe be reliant perhaps on the age of the perpetrator or the age of the person. And I've heard of states that have formulas to address this so that if the ages are similar and the conditions are perhaps different, but if somebody is 30, 40, 60, 70, and they're the perpetrator, then perhaps some of that justification is changed. But I appreciate that, and I'll go back to revisiting some of those formulas because it seemed like they made a lot of sense, and maybe that's something to look at. And with this, I noticed that the increase of the minimum time for first, second, and third degree increased it to that same minimum. So is that an issue if they are all increased and they all become the exact same starting penalty? I worry with some of the thinking that might be behind it. I've heard that people can worry or face situations where if the penalty is essentially the same, if you're conducting a third degree crime and you're going to be punished the exact same or a very similar way to the first degree, I worry that it might just add to the number of first degree crimes because maybe in their thinking it's all the same or nearly the same penalty. Do you have any input on that? I mean, you're much more familiar with that industry and those types of thinking.
Senator, I can't comment on what someone would be thinking in that respect, but I do think it is important to distinguish between levels of an offense in these types of cases and in other types of cases as well, because the higher level offenses usually imply a threat to society or level of harm to the victim that I think is important to distinguish in metering out punishment for the offenses.
And the third question that I have here is, you know, in looking at a lot of these laws and having us consider adjusting them, I'm not sure that they all make sense altogether. It kind of seems like something has changed here, something has changed there, and I'll be asking later on in some of the other bills about the reasoning behind why sometimes it's increased double, other times it's increased triple, and sometimes it's increased just differently. It didn't, I wasn't able to follow the reasoning for that. So if these increases go into effect, does this make sense with what exists for our, within the juvenile portion of how we treat juvenile crimes? So if we increase it very heavily at this adult level, I'm wondering how this now makes sense or doesn't make sense with what's happening with juveniles that might commit crimes. With this one, it might have, it might be less connected, but in some of the others, like robbery or what have you, but certainly juveniles can be, can commit crimes like this. But if you could speak to that, how they would or wouldn't fit together?
Senator, what I would say on that is I think the research shows that juveniles' brains are still forming until sometime in their 20s, essentially, and that they're not fully the person they're going to be for some time. So I think it's obviously important to treat them differently. I can't say that I feel that it would change how a juvenile would necessarily behave, knowing that this adult law is on the books, so I can't speak to that. I would say in general, though, the conception that our judges are taking it easy on people charged with these sorts of crimes, I just have to push back against. That's just has not been my experience. These are very difficult cases. When there's a conviction for one of them, the defendant already expects a very high-level sentence. In some of my cases, it wasn't unusual for someone to be sentenced to life without the possibility of parole. That's a sentence that already exists on the books. In another case I got, a defendant received a 40-year sentence that was, in all likelihood, a life sentence. So I believe that there's already adequate safeguards in our laws to result in sentences that are quite high.
I had said that was my last question, but actually I have a couple others.
Senator, if you wouldn't mind, maybe we'll go down the panel and we'll come back to you for the next couple questions.
Can I just ask this one
for
that follows
follow-up?
up on
Sure.
that? Yeah. And so the other way that I was thinking of this, and again, you have more expertise in this area than I do, is, and maybe more so for the robbery and the other laws that we're going to be looking at today, but I have heard that if penalties are increased at the adult level and they remain markedly different for the juvenile, that there can be an increase in incorporating juveniles into the situation so that if somebody's caught, it may be them, or and they will get the lesser crime rather than the harsher crime. Is that anything that you have to speak to?
I don't have any particular comment to how this law would impact our juvenile justice system. Those laws are distinct and I would say speak for themselves. I don't know that there would be an impact on the juvenile justice system as a result of this adult bill.
Sejus Masi, I would worry about that, but thank you for providing that. Sejus Masi,
Thank you very much, Senator. I'd like to recognize the presence of Senator Will Castro. Senator Castro, thank you for being here. And we'll go now to Senator Amanda Shelton, Senator Torres, Senator Muñoz.
Madam Chair, I'd like to reserve my questions until after the next bill.
All right. Senator Taitigui.
Thank you, Madam Chair. Thank you, gentlemen, for being here. And Frank, come on up. Don't run away. We're gonna hit you up. Don't think you can get away with not state your case and not answer any questions. You know, I think the bill is intended here is to find some kind of solution, you know, to our growing epidemic of crime, especially in this area of sexual criminal conduct. You know, in drugs, when people are arrested for drugs and they're given treatment, you know, for the issue, the addiction. You know, what we're doing today is trying to find a way to keep sexual predators away from people. It's never been proven that sexual predators can be treated, but what we can do is keep them away from our public, from our children. And I think the bill has good intentions in moving forward. Now, anyone can get on the internet and put out statistics, and just like, you know, recommendations from one a website to tell you that this is the way to go, and another one. So a lot of the questions that were asked by my previous colleague, you can even answer, you know, and because there really is nothing out there. But this bill is finding a way to keep people away, you know, sex predators away from the public. And, you know, Frank, we know our jail or facility is full at this point, but that's no excuse for allowing these people to stay on the street. And as the director, I hope you're going to find some solutions, tent city, whatever it needs to, you know, you need to do moving forward. But I think you know, the bill, definitely we can look into some of the other stuff on it, but the true intention here is to preventive, and it's been shown in some statistics that greater penalties for crimes has deterred individuals from committing crimes. You can't say it hasn't, because it has. So I greatly appreciate it, and Frank, I'm looking forward to seeing what you have up your sleeve to be able to, when we catch these individuals, prosecute them, they stay in jail.
You know, you got different levels of CSC, criminal sexual conduct, and I think often, most of the offenders are men, of course, and often we have the different levels, the touching and that sort of thing. I think those situations can be addressed, maybe pretrial diversion as an option. We do pretrial diversion for drug offenses, and we don't have that opportunity for sex offenders. I think we need to separate the predatory sexual offenders versus the stupid ones who think it's okay to touch people. And I think there's a big difference in those kind of offenders. And I think that the risk is we're going to take these stupid, touchy-feely people and mix them up with the hardcore inmates, and that makes it more difficult. So I go back to treatment, and I think treatment, you know, we had a roundtable months ago on the parolee, Mr. Mofness, and how he failed. And I can talk about Mr. Mofness. He was a model prisoner, because in prison we don't have little girls running around. And so I think we identified in your roundtable, Madam Chair, that there was a need to up the ante on risk assessment, on maybe extreme measures of assessments, even to polygraph examinations and pictures and stuff like that. And I think we should be doing that for these hardcore ones, but for the stupid, touchy-feely offenders, I think we need to separate them and maybe do pretrial diversion, more probation versus incarceration, and a lot of supervision at home. And I go back to supervision at home because most of our prisoners who go to DOC, most of them get released. At some point, they become parole eligible, and if we keep them in there too long, the chance of success at parole is diminished. And we want them to be successful. And a lot of that, part of that's our fault, because we don't have enough parole officers. And I think Senator Moylan would appreciate that more than anybody. We don't have enough parole officers today. Our parole officers are spending their days prepping for the next parole hearing. They're not out there doing bed checks. They're not there on the job site, making sure that they are compliant with the conditions of release. And so they get in trouble. And so I think we should talk about a comprehensive plan to assess risk, separate the low risk from the high risk, and then offer treatments and pretrial diversion. And for those who are incarcerated at corrections, we need to do a better job of getting treatment. So we are actually working on those thoughts as we speak to better deal with treatment. Because I go back to the inn is full. We are overcrowded. And if we decide to go on harsher punishment and longer sentences, we're going to have to build bigger and bigger prisons. And to do that, I mean, there's extra cost. And I don't want to get into the politics of do we want to build schools or prisons. And I think we would prefer to build schools and hospitals before we would build prisons. So those are some of the challenges you all have to make decisions on.
Thank you. Thank you so much, Frank, for that. And, during my time talking with the public all of last year, even during the campaign, the number one concern on everyone I spoke to, 99% almost, were all said public safety. So if we need to build a bigger, prison, then that's what we need to do. Okay, thank you.
Thank you, Senator Taitigui. Senator Vigel?
Thank you, Madam Chair. This question is for the gentleman from, is it the Public Defender Service Corporation?
That's right.
Forgive me, I didn't catch your name.
It's John Morrison.
John? Okay. Thank you. My question is with regards to testimony that's submitted, written testimony actually, and in it, there's a section here that says, mandatory minimum bills are unnecessary. The first premise of this bill is that criminal sexual conduct cases are on the rise. A look at the Uniform Crime Report and the most recent Guam Police Department citizen-centric report seems to contradict this claim. Could you expound on that?
Senator, this is a document that was prepared by our director. These are the statistics that he cited in his testimony. That now I understand that things get reported in the media, and it's easy to cause a panic. But from these statistics, it doesn't appear that these types of cases are necessarily on the rise. That there's actually appears to have been a decline. So those are my comments on that. If I could.
So these statistics are based on these reports, Uniform Crime Report and GPD Citizen-Centric Report. How confident are you in the veracity of those statistics?
Senator, I just read the testimony that was prepared by our director. I don't have any personal knowledge about these statistics, so this is really just something that I wanted to provide.
How about at least anecdotally as a public defender? What does it look like to you? You're in the trenches, so to speak. What do you see?
Senator, I haven't noticed any appreciable changes. These have always been a fairly high volume of our caseloads. These are the cases that are most likely to go to a trial. I have not noticed an incredible uptick in these sorts of cases being charged out. It seems to be more or less consistent, or fewer to me. I will say that perhaps more of these cases have gone to trial recently, and I think that's for a variety of reasons, including time standards that were imposed on the judiciary, changes in the Attorney General or prosecutors within the office that want to take those cases to verdict more frequently. But I believe that they're going to trial more often. I don't necessarily feel that they're being charged out more often or occurring more often.
Ah, I see. So from what you've seen is you've seen an uptick in them going to trial.
Yes.
Okay. And then that could also increase the news cycle on a particular crime because first the guy's in the news. I'm speaking as a former journalist. I kind of know how these things work. So as the guy first gets arrested, he's in the news, and you see it, news for criminal sexual conduct, arrest. Then it goes to trial, and then during the trial, there'll be repeated stories on the same guy for the same offense. So you're not seeing an increase personally in the number of cases of criminal sexual conduct, but rather perhaps an increase in the number of cases that go to trial. Is that correct, what you're saying?
That's exactly my testimony. I have not personally felt an uptick in these types of cases being charged out.
Okay, thank you very much. Thank you, Madam Chair.
Thank you. Senator Castro?
You know, Chair, I don't necessarily have a question for the panelists, but I do want to state for the record that in the brief time I've had to listen to this conversation, you know, I hear a resource question, and forgive me, you know, I have a daughter, I'm sure many of you have children. And then I started hearing this conversation about touching silliness, stupidness, whether it's a lapse of lapse in someone's judgment. But I'm trying to rationalize this, and so I'm thinking that on page 2 and 3 of the proposed legislation, you know, I see words like sexual penetration. And frankly, admittedly, I don't know how to legislate that. But based on my gut, I just think it's a sick thing to society when an adult traumatizes a child for the rest of their life. I don't know how to legislate that 15 or 25. I actually have other ways to think about it and in my own little world deal with that. But, Madam Chair, I just want to say that for me, it's the least of all arguments that merits my attention on the floor should the bill proceed would be one of resource. Or I can deal with rehabilitation and some discussion, but until I wrap my mind around it, you know, I'm hearing better supervision at home, and I'm just thinking in a fraction of a second you can restrain a young woman, a young girl, my daughter, and penetrate her one way or another, and you're telling me that I've got to do a better job. And I'm not saying you're saying, I'm saying these are the plausible discussions we can have. And I usually don't want to have these discussions on the floor because I tend to walk in with the statistics. I tend to rationalize for myself to make an even-keeled decision. But this is one that hits home, that's right there in the gut, you know, and I just want the author of this piece to know that I stand with him in principle. And this is where I'm going to plead to the panelists, yourself. I think we're actually neighbors physically. I would love to come over, and forgive me, Chair, for missing the roundtable, but I want to understand this. But it would be a weak argument to anyone who puts forward on the floor that this is a resource issue. In my humble opinion, this is, or an issue of frequency, rise or decline. One daughter, one shot. That's all it takes for me as a human being, as a father, to personally be traumatized. I'm not really expecting a response. I don't mean my comments directed at you, sir. I'm just.
It's fine if you do, and I'm happy to offer a response.
It's okay, and I'm not looking for one. I just want you to hear as a voter, and my colleagues to hear as a potential vote on the floor when it emerges. This is a morality issue. This is an issue of child safety for me. So, again, I don't mean to pontificate. It evoked a very emotional response, and I will look forward to the statistics and actually share a household with someone who has a PhD in criminology, youth deviant behavior, and I'm almost afraid how she's going to react to my reaction. But I just wanted it noted for the record that there is no compromise when it comes to penetrating a child against his or her own will. Thank you.
Senator, I guess the only response that I could offer to that is it's really a question of, are the judges on the bench able to weigh the facts and determine what a fair sentence is? We believe that they're capable of doing that, and that the sentencing laws currently on our books allow them the appropriate latitude to fashion a sentence that isn't a cookie-cutter sentence that's going to take into account important considerations. That's really the gist of what we're trying to get across here.
Counselor, I appreciate that. In response, Madam Chair, this will be my closing. Again, no response is necessary. I just think once you do it one time, that should be the last time. As a matter of fact, thank you. I'd like to see you offline and your team and understand and help me come to a better understanding. But until then, thank you, Madam Chair. No response is necessary to my reaction.
Thank you, Senator Castro. Before I allow the sponsor to close, I just want to point out, so we've received a fiscal note from BBMR, and BBMR says that this bill is administrative in nature and therefore it has no fiscal impact. And we've also received review by our legal bureau here at the Guam Legislature, and so they've made recommendations as to the language, especially the phrase that says, or the actor does not know the victim but coerced the victim to submit. They've recommended we change that language. They've also recommended some other technical changes, pretty much. But as far as your testimony, Attorney Morrison, Senator Shizaki's right that we did several months ago have a roundtable trying to get to the bottom of not necessarily what we perceived as an increase in criminal sexual conduct cases, but we saw these offenders out on the streets again, recommitting criminal sexual conduct. And that was a concern, and I wanted to get to the bottom of how to solve that. And we discovered at that time that there were very stiff penalties available to the judges. And so you say in your testimony that the judges will impose a long sentence already permitted under the law. I guess if we can get hard data on this, I have asked the courts for that, then that would, satisfy the committee. But it was our impression just from what we read in the media, it's hard to gauge, right? Whether they are imposing stiffer sentences for criminal sexual conduct or not. And it didn't seem to us at the time that they were availing themselves of the stiffer penalties that are available. And I wanted to know why. Why, if we have a life sentence available to them, they're not using it? And so part of it, it was my understanding that, we're trying to understand the nature of criminal sexual conduct, and that is evolving as we learn more over the years. So I think it's very much evolved. And so that's why we started to talk about assessments, and we started to talk about whether treatment was even available on Guam or not, and whether if we put them in prison for a certain sentence, if treatment is not available, it was my contention that the courts should know that, so that they factor that in their sentencing, that they will not be receiving rehab, so you will be letting them back out on the street after the sentence is over, with the probability, according to science, that they might reoffend, especially those, as you call them, predators. Those, and but I also note in your testimony it says there are many reasons a case charged out as a first-degree felony gets resolved with a plea agreement to a far lesser offense. The main reason is because of these mandatory minimums. So this point has been brought up to me by the lawyers, and if you could explain that, maybe as so that we could all understand, because we are very concerned with plea agreements, right? That's another thing that in the media is very criticized. Plea agreements, it's always lower than the original charge. So if you could just explain, how does increasing a minimum sentence affect plea agreements, or the frequency of them, I guess?
Senator, my impression is that increasing the mandatory minimum basically fast tracks the case for a trial. It's much more difficult to work out a plea agreement when there's a mandatory minimum, and I mean the reason that they're going to offer any sort of reduction in the sentence is because there are problems with their case. Their complaining witness doesn't want to come to court. Their complaining witness has been inconsistent. There's usually some good reason that they're going to offer a plea agreement. So, I mean, the idea that judges or prosecutors are sitting back and deciding to take it easy on people, I think, is just a misnomer. The mandatory minimums, I think, have caused a lot more cases to go to a jury trial, and everyone has to live with the results of that.
Accurate in rephrasing that. They are going to jury, more cases with mandatory minimums are going to trial because they would rather take their risk than face a mandatory minimum. There's no other way out of that.
I think in my experience that's in large part true. That was my testimony, yes, that these cases would be much more likely to go to trial, I think, and then the complaining witness would have to actually appear in court, which is frequently very difficult in these cases.
And so the likelihood or that the perpetrator will assert that he wants to go to trial or speedy trial is, do you believe, putting pressure on the attorney generals to agree to plea agreements instead of risk a not guilty at trial? Is that how it's affecting plea agreements? Or if you could just tie that in.
I think I'm going to have to rest on what Director Ettore put in there as far as his personal beliefs of what the result of this is. I would say that my personal view in my practice has been that the inability to suspend a mandatory minimum has resulted in a lot more cases going to trial, and it's just because there's nothing left to negotiate. Now the victim's going to have to go through the entire process, unfortunately.
All right, I appreciate that, and I appreciate both of your testimony. Thank you very much. Okay, Senator Moreland, you may close on the bill.
Thank you, Madam Chair. A stronger message needs to be sent to the offenders of crimes. And as a community, we are continuously seeing criminal sexual conduct, specifically with those preying on minors. The victims of an act of criminal sexual conduct are scared for a lifetime. And almost every state has adopted some form of sentencing enhancements as a way to fight crime. When it comes to criminal sexual conduct, a strong message must be sent to the community. Amending sentencing laws is just one of several priorities in addressing this problem. And much more must be done by the government and communities in helping the most vulnerable and this is just an important start. Thank you, Madam Chair.
Thank you very much, Senator Moylan. It is now 1:58, and we will proceed with the second item on the agenda. Bill number 125, sponsored by Luis Borja Muñoz. Senator Muñoz, you may introduce the bill.
Thank you, Madam Chair. I'll start by reading the title, Bill number 125-35 LS. And if I may, Madam Chair, ask the Attorney Morrison and Director Ishizaki to stick around for additional questions in case I have any. Thank you. This is an act to add new subsections 25.15D and 25.20D to Chapter 25 of Title IX, Guam Code Annotated, relative to sentencing and special parole enhancements for individuals convicted of first and second degree criminal sexual conduct involving victims under 12 years of age. Madam Chair, the informal name for this law that was given in 2005 in Florida is called the Jessica's Law, as well as other laws in several other states designed to protect potential victims and reduce a sexual offender's ability to reoffend. The name is also used by the media to designate all legislation and potential legislation in other states modeled after the Florida law. 42 states have introduced such legislation since Florida's law passed. The law is named after Jessica Lunsford, a young Florida girl who was sexually battered and murdered in February 2005 by John Coey, a previously convicted sex offender. Public outrage over this case spurred Florida officials to introduce this legislation. Among the key provisions of the law was classifying lewd and lascivious molestation on a person under the age of 12 as a life felony, and a mandatory minimum sentence of 25 years in prison and lifetime electronic monitoring of adults convicted of lewd and lascivious molestation against a victim less than 12 years old. The statute also requires that if an offender is sentenced to a term of years, he or she must be given lifetime probation following the imprisonment. The sentencing guidelines that will be enacted by Bill number 125-25 follow those used in renditions of the state-adopted versions of Jessica's Law and apply to those who sexually assault children under 12 years of age. The sentencing recommendations will run in place of those sentences of the Vulnerable Victims Act that are much longer. First-degree criminal sexual conduct on a child under 12 will be punishable by 25 years to life in prison, and second-degree criminal sexual conduct on a child under 12 will be punishable by 15 to 25 years in prison. The sentences do not prohibit parole, but they do prohibit probation and prohibit consideration as a first-time offender under the Safety Valve Act, a subject pending under Bill number 52-35. Madam Chair, this past weekend we saw another arrest of a man accused of sexually assaulting two girls, ages 11 and 12. Last year, we saw several arrests involving victims under 12, including one where an 11-year-old child was impregnated by her abuser. In that case, the child was not the abuser's first victim. The cases at the subject of Bill number 124-35 Gomia involved two victims that were 8 years old when the abuse began. Our criminal justice system is just not tough enough with these sexual predators, many of whom seem to feel that they will continue their predatory behavior as long as they believe they can get away with it. Defense attorneys may insinuate that tough sentence may discourage plea bargaining. This means young victims will have to testify at trial. Young victims are often traumatized by cross-examination by defense attorneys. There's nothing wrong with plea bargaining, but the floor for plea bargaining should be a minimum of 15 years, not 1 to 5 years as its current practice. These pedophiles will face 25 to life under the bill. I believe 15 years is a gift. Madam Chair, this article, now I know we shouldn't quote the media because, the media can sensualize or consensualize some incidences. But just to even read this, if I may. The abuser here allegedly threatened to kill them if they told anyone. Now, I give courage to the 12-year-old girl who came out and told someone because she put her and her younger sister's life in danger. But she was brave enough to do it. And just to read, one of the paragraphs here, and it chokes me up because I have a daughter. We all have children who are either young or have been young. And just imagine yourself in this position. The older sibling also said the younger girl looked as though she was crying, but she couldn't be sure because the younger girl didn't speak. I went to sleep last night crying, Madam Chair, because I was reading through all these magistrates last night. And this is public record. If you guys want to see this, just take a look from January 2018 to today. How many crimes or magistrates are against children under the age of 12? And if you read this, you will be so disgusted with what we have done as a society to protect these young kids. And I just want to say that, I just want to thank Director Ishizaki for distinguishing between stupid and chronic, because there are stupid, and then there are people who are pedophiles. But what this bill will do will prevent that stupid from happening. It will send a message that you're not allowed to be stupid before you become chronic. I mean, we talk about reoffenders, right? But how about let's protect the victim, the first victim? How about let's take a stance and protect the first victim, not protect the second or the third or the fourth. Let's protect the first. And that's what this bill is going to do. It's going to protect the first victim. So I just want to thank Director Ishizaki for pointing out that there are two classifications of criminal sexual conduct. But who are we here to protect? The criminal or the children? Now, I know, Attorney Morrison, you said that the media doesn't often report everything, right? And the magistrates here, they're the truth. If you read some of these, I couldn't even get past 2. I couldn't. I don't envy attorneys. I don't envy you that you have to go through this and take this home with you and sleep at night. Because I couldn't sleep last night. I don't know how you do it. I don't envy you. There are so many cases that go unnoticed. So many that are not even written down in paper. You know why? Because their lives are threatened. They're threatened that they're going to be killed or hurt even more if they report it. So many. What this bill is doing is it's sending a message to those pedophiles. Now, pedophiles are people who are attracted to pubescent children. These are defenseless kids, not even in middle school yet. They're still in elementary. Now, what's the difference between a teenager and a child who's not a teenager yet? Well, maybe the difference is in their vulnerability, their size. Maybe a teenager who's 14 or 15 or 16, 17 can fight off their abuser. But imagine a young, innocent kid. Let's tell that 4-year-old girl who had to get surgery to correct her hemorrhaging from her abuser to find a balance. Let's tell the family, we're going to find a balance for you. Is this the message we want to give out? No. The message is, you're not allowed to do it at all, period. Sorry, Madam Chair, I get very emotional and passionate about it because I didn't realize how terrible this is until I started reading this, and I couldn't continue. I invite the public to just take a look at it because it's public. And then you feel the same way. Like my colleague said, enough is enough. Thank you, Madam Chair.
Thank you, Senator Muñoz. We will, before I accept testimony from the panel, I want to state again for the record, for this bill, that the committee has requested feedback of the Attorney General of Guam, the Judiciary of Guam, the Guam Police Department, Child Protective Services, the Victims Advocates Reaching Out, Guam Coalition Against Sexual Assault, the Public Defender, the Guam Bar Association, and other stakeholders. And we will now hear from two members of the Guam Parole Board. Ms. Lena McDaniel, you may begin.
Thank you, Madam Chair, Senators. Initially, I wasn't going to testify, but hearing the dialogue from the first bill and looking at this 125-35, Director Ishizaki, and then also from the Public Defender, Attorney Morrison, and hearing Senator Marsh, Senator Muñoz, Senator Castro's feelings about what's happening and their concern, right? I've been on the board since 2017, and they're public hearings, so the public is allowed to come. When we interview not only the victims, the inmate or parolee's family members, or the inmate and the parolee when they're either applying, seeking parole, or they're being revoked. And I can't say statistically if there's an increase in the criminal sexual conduct, either asking for parole or the revocations. It does start at home, Senator. And as a community, as a board, what we've found, or at least my experience has been, is that if you're going to identify or you're going to separate between those that make bad decisions because they, were reckless, stupid, and touched inappropriately because they're like that borderline age, Romeo and Juliet, or there's that predator. That's what we're seeing. That you can find we're finding those predators, and we're seeing the ones where, this 21-year-old just got intoxicated and didn't pay attention to when there's either flirting or whatever the scenario is, and didn't know the difference from where no meant no, to where the predator, where there are so many cases where, yes, it's happening at home, and a male or even a female in the home is touching a young child, a minor, and the family members are not reporting it because they don't want the shame coming to the family. Then, because it's not reported, that person then becomes a predator because they just keep doing it to the next family member, because they're the ones that are told, you better not tell your mom, better not tell your father. So there's that fear that starts at home. Yes, it does start at home. We need to do we need to educate more, and then also hold our home accountable. Go back and educate the family that if it's happening, you're just as responsible, because I have told mothers, why are they saying that their 15-year-old daughter, it's inappropriate to have a relationship with a 40-year-old man? That's inappropriate. We're both mothers of the inmate and mother of the victim. Then to find out that this inmate had relationships since he was 18 with another 18-year-old. So if that's happened, he could have had inappropriate relationships when he was a minor himself. And if it didn't get stopped in that household, that's why he became a predator and victimized other young girls. So it's not only the courts that's responsible. These mandatory sentences, the special paroles, yes, but the director's right. There's only 5 parole officers. And if they're getting ready for the hearings, there's a lot of administrative work that they have to do to prepare a parolee for his parole hearing. We don't even have a secretary who should be doing that. It then falls back on the parole officers to all come together. And sometimes our technology is not even working accordingly, and we cannot Skype them in or video chat them in. So it's more than just writing these mandatory minimums. It's more than just, getting the assessments done. We need to educate our island community, yes, so we can protect our minors here on Guam, so there's no more inappropriate touching or the criminal sexual conduct. Because if you go back, and statistics will show that a male who is a perpetrator probably was assaulted himself as a minor. Thank you.
Thank you very much, Ms. McDaniel. Our newest member of the parole board, Mr. Camacho, former chief. Please proceed.
Yes, good afternoon, Senators. Thank you very much for allowing us the presentation here. I've had many years, almost 20 years.
Could you just please go ahead and state your name for the record?
My name is Robert D. Camacho. I'm part of the parole board, Guam Parole Board, and former director of DOC and also former parole officer. What I would like to say is that, almost 20 years I've done pre-parole studies for many cases, and which include criminal sexual conduct. So I'm really going to share some thoughts regarding this and the importance. And I do support the bill. I do support the bill. But I want to kind of explain some thoughts also about the laws and what the intention is. And there's 2 parts. One is the deterrence, right? And the second part is justice for the victim and retribution. And the public demands that we do something. And that's the whole core of it. Does it deter, and should we punish this individual for what he has done? And the question of deterrence that's always been a question for decades. Sometimes, you look at drugs, the war on drugs. We still have drugs. Murder. We increased it. Before it used to be 15 to 25 years or what have you. We still have those cases. And the same thing with criminal sexual conduct. Could we stop it? That's a question. I'm not sure if that's going to be on the person's mind when he's, doing these crimes. Possibly, yes. Maybe, maybe not. I'm not sure. I'm not an expert on those type of statistics, what have you. But what I do know is that we do separate the offender from the victims and the community. That's 100% true already. So throughout the years, I'm interviewing hundreds of victims regarding, it is heart-wrenching, and I understand Senator Munoz's emotion behind this, because even as a parole officer, and you hear these tragic criminal acts against very young children and the trauma. I've had situations where I went to look for a victim of a certain criminal sexual conduct, and they start to, panic and get emotional because how did you find me, and those kind of questions. And some of them, where I located them at their work, the next day they quit. They ran away from their employment because they don't want to be tracked down, and they don't want to testify. That's the kind of emotion that you have to deal with. And, you see these victims relive these horrific crimes. And there's, it bothers you no matter what. As a parole officer or what have you, interviewer or caseworker, and you listen to these very difficult stories of crime that has been committed against them. The other part I want to also mention is that when we say sexual crime, criminal sexual conduct, really it is a crime of violence. It's not just sex, it's about violence and power. And that is the foundation of how these things happen. It's an emotional thing. And I remember Ann Donnelly, who was a psychologist at the Department of Corrections, and we were talking very extensively about crimes of criminal sexual conduct, and especially the pedophiles. And she mentioned to me, it's one of the most difficult treatments in her cases because it's an uncontrollable emotion that they cannot help themselves. There's something that triggers mentally inside the offender. And so that is why you will see that many of these pedophiles are repeat offenders. Repeat offenders. And if you look at the statistics, and I've seen it throughout my years, through criminal sexual conduct, there are many, many cases where they come back for some reason or another. And we saw that with our parolee a few months back. And when we talk about trauma, all we got to do is look at what has happened in our church and what happened with the scandals in the church, and just coming out. But many of these situations have been long known by many family members, that situation, but they did not know what to do. And they felt powerless because of the status of the individual. And this is what I've seen in my many years of doing pre-parole studies, is that it does, many of them start in families or known to the family, a close family friend or somebody that they know. And then many times the parents don't believe the victims. Or they believe, but they remain silent, as my colleague says. So when we look at these things and we look at the, minimum sentences and maximum, we're not far behind what happens in the federal court. The federal court does these things. And I know that the Honorable Judge Pryor had mentioned certain things or what have you regarding the minimum and whether or not it's effective or not. But the federal government still does it. I mean, just take, for instance, just recently, this guy was caught with a barrel full of cocaine, and he's serving 54 months. But, why? Because he just found it, and he was a meth addict, and, what have you. And so they had a range of things like that. And to the eyes of the public, this is, wow, this is ridiculous, right? But to the courts, there's some range. And I'm not sure if there is a right answer for everyone. There is no right answer, really, but making it harder for the individuals to go back to the society is a good thing. It's a good thing. I know that it seems unfair sometimes, and as it's written down here, one is that there's possibly injustices and so forth, and because there might be disparities. And I'm not sure at what level that might be, whether it's a racial thing or is it economic thing, the rich people, get away with it and the other ones don't. I'm not sure. But the whole thing is this, is are we protecting the community and the victims? And that's probably the most definitive assurance. We don't know if it's going to be deterrent. Yeah, it could be. Maybe, maybe not. I'm not sure. But we do know one thing. once they are serving the time, they can't do any more harm to anybody else. And I know there's several bills on increasing the sentencing for many of these other cases like arson and so forth. And I agree, we do, as Senator Moylan says, we do need to set an example and show that we are tough on crime. The most recent one I saw was where these two individuals attacked a tourist. And, it's just, the optics is going to affect us economically if the tourism industry, starts to fall down because of that. And, people, the Japanese will put that on their public, news and what have you. And so that might affect us tremendously. So it affects everyone. So when we look at this kind of thing where we are mandatory, please consider when we have a budget hearing that you support increases in the budget for the Department of Corrections. And I've attended many public hearings, public safety hearings with the governor and Senator Moylan and what have you. And I truly believe this one whole thing, that the answer to our reduction in crime lies at the Department of Corrections. Why? If our recidivism rate is about 75% or what have you, and we treat those individuals, whether it be for burglary, arson, or what have you, CSC, and we take care of those issues, whether it be education, anger management, drug addiction, anger management, whatever it is, education. If we resolve those things correspondingly, there will be an improvement in our reduction of crime out in the community. Because if the recidivism rate is high, taking care of those individuals inside the institution is going to be very helpful. Be tough on crime, but also be such a strong advocate of rehabilitation. As we go along and you make these sentences harsher, please please acknowledge that there will be no time in this history that it will be reduced. This is like the mark. This is the bar that you're going to be setting. We're not going to, no senator or no public individual is going to say, oh, well, let's reduce criminal sexual conduct to 15 years or murder down to 15 years or what have you. This is going to be the bar that is going to be set. And so, as you make your decision, realize that this is it. This is what's going to set the bar for years to come. But at the same time, correspondingly, please consider that 6 caseworkers, 1 psychologist, and 700 inmates is just not going to be helpful for any. Adding to that, I made some research over about 10 years ago of DSU population was about 500. We're now at 700. That's a 40% increase. As you increase the sentencing and making these mandatory things, I can almost, if we're going to look at the stats, within 10 years, there will be another 40%. So we're going to be looking at 900 to 1,000 inmates. So please consider that and look forward, not just for this year, but 5 years, 10 years down the road as we continue on with this. And that's my whole gist of this presentation. Thank you very much.
Thank you very much, Mr. Camacho. Attorney Morrison, did you want to testify on this bill? Yes.
Senator, I read Director Hattori's testimony in the last one. He has a piece of submitted testimony for this bill as well. In large part, it reflects some of the same arguments. I would just say, in addition to that, that judges are judges for a reason, and I don't believe that these types of cases anyone is getting undue consideration from them. Sentences are frequently handed out that are very harsh to reflect the seriousness of the cases. and that appears to be the appropriate standard rather than have one size fits all for every type of case involving these facts. I would echo some of what the first testimony indicated, in that I too have experienced that when I have a case like this, it's frequently pointed out in pre-sentence reports and occasionally at trial that the defendant was a victim himself at some point in the past, and I just don't think I can fail to mention that fact as well. I understand that these cases are very upsetting. I've been licensed to practice law for 18 years. I've been on Guam since 2008. I started making appearances in very serious cases like these sometime around 2004, so I understand that these are emotionally charged issues, but I just ask the committee members to take an objective look at allowing judges to be judges and weigh all consideration. Thank you.
Thank you, Attorney Morrison. If I may point out that we've not received a fiscal note on this bill yet. It's still pending. We did also receive some recommendations from our legal bureau, which are in regards to the, after an offender has completed their sentence, to requiring them to submit to electronic monitoring at that point. So they want us to further consider the potential Fourth Amendment issues raised by imposing that after completion of a sentence. I also wanted to point out, so the section of the law that is being affected by this bill is 25.15. They're adding a new D and a new E. No, they're adding a new D to 25.15 and 25.20. Both of those sections are in regards to criminal sexual conduct. Both of those sections were also discussed in the previous bill that we just discussed. So in that bill, well, in the current law, the current sentence for first-degree criminal sexual conduct is 15 years minimum to life imprisonment. That is what the judges have before them, available to them. And they define in the law currently that first-degree criminal sexual conduct is if the victim is under 14 years of age. So that's already defined in the law, and the penalty for that is potentially increased under the vulnerable victim statute. If a victim is a vulnerable victim, there are several types, but one is a child who is 13 years old or younger at the time the crime committed upon him or her also makes this person a vulnerable victim. So they have an additional, looks like up to 5 years imprisonment that can be added by the court system. So that's the current law. So this law now would increase that minimum again from 15 to 25 for victims under 12, which are already covered under the first-degree criminal sexual conduct. But so it would increase from 15 to 25, yes. And it puts restrictions again on work release and education programs. And it sets a minimum for 25.20, which is second-degree criminal sexual conduct, a minimum of 15 years. And the current minimum is second degree. Just 1 second. All right, I lost track of that. Mr. Morrison, do you know the current 2520 minimum sentence is for second degree criminal sexual conduct? I lost my chart. 5 years, is that correct? I just want to show what we're trying to do here. So they're trying to increase it. Sorry, give me one more. There it is. Yeah, first degree they're proposing to raise from 15 minimum to 25. And for the second degree, the current is no minimum and no maximum. And they would propose to put a minimum of 15 and a maximum of 25. All right, with the enhanced penalties also available for vulnerable victims. Is there anything you want to clarify with that, Mr. Morrison? Am I stating that correctly?
There's a lot of numbers flying around, Senator, but what I would say is that some of our current CSC laws that don't specify a punishment, you have to look back at what the general sentencing terms are for all first or second degree felonies. So that's how that would work. Not that there's not a minimum, but that there's a range that's set out in the law.
That's right. I have that also. And it is like a maze for us who do not practice criminal law. And that's why I'm hoping that you and the Attorney General will weigh in on this, because it's you who's going to be interpreting these statutes. All right. So questions from the panel? Senator Muñoz, would you like to begin, or you want to end? All right. Senator Taitagui? Senator Castro?
Thank you, Madam Chair. First of all, I want to thank Ms. McDaniel. Thank you for adding to the conversation along the lines of what Chief Ishizaki had mentioned. So I appreciate that. Also the testimony from Mr. Camacho, also yourself, Mr. Morrison. So, to your call for reason and looking at this objectively, I'm willing to, again, sit down and have that discussion on the mitigation strategies, whether it's how we manage our households or what we teach our children in order to look out for these warning signs. But let me be clear, perhaps more clear for Senator Muñoz, who's the author of this piece, if I could use this as an opportunity to further qualify my position. While I'm willing to discuss mitigation strategies and take into consideration other things, I want to be clear that I do support a minimum of 25 years without the possibility of parole. Perhaps even, I would suggest in another discussion, without being even possible for a pardon if it's for the first degree criminal sexual conduct. And this is in the context of those heinous crimes performed upon a person's 12 years and below. So I just want to make that clear. While I'm willing to sit down and learn more about these strategies, there is no wavering on my part when it comes to committing a heinous crime upon a child in the first degree. Thank you.
All right, if I could just reiterate. So second degree criminal sexual conduct is a felony in the first degree. And so felonies in the first degree, the court shall impose a sentence of not less than 5 and not more than 20 years. And I think there's another statute also that says that violent offenders are not eligible for parole. So first degree criminal sexual conduct definitely is not eligible for parole. Thank you. All right. Any other senators on this side? Senator Marsh-Titano?
Seduce Masi, Madam Chair. Again, it's very important to hear all the testimony. It is absolutely important for us to make sure that our systems are in place, that are making strong statements in ways that make sense for the community. We have a lot to protect. We have a lot that we want to improve. And I also I appreciate the testimony that really helped explain how these are really complex situations. There can be all kinds of factors involved, from being victimized themselves, from being in a family where one isn't believed and then isn't protected. It can be very messy, and we really need to work to address all of it. The child, the parent, the family, the neighbors, all of it. I do want to get back to the age again. It does seem that there's just this real inconsistency for 12 years here, 13 years there, between 14 and 16 here and there. So I would ask the author to consider looking at the possibility of raising the age, because as I mentioned, we've heard that in some cases it's 12 and in some cases it's 13. And I think about that vulnerable 13-year-old who deserves every bit of protection and care as somebody who is a week younger, months younger, several months younger. And maybe there is something that when a certain age is reached, based on more updated analysis than we've had decades past when some of these laws were written, perhaps we could look at that formula approach or some other approach that makes sense, but protects as many as possible. And I'm sure that's the intent of the author. We're out here to protect as many as possible. Because we've heard, and I thank the chair for providing some clarification about what can happen for a 13-year-old. Can somebody let me know what does happen for those that are between 14 and 16? Does anybody know what the sentences are for the different first and second and third degree crimes there? So we've talked about up to 12 years old and 13-year-old, but just to understand.
If I could
maybe-
just weigh in, if
Yeah.
they're not those young ages as required by the first degree criminal sexual conduct, then they would be considered, they could still be first degree criminal sexual conduct based on other conditions. If there was a weapon, other conditions that are stated in the law, they could also be a, second degree. The age doesn't restrict, but it's that young age says right away it's first degree. It's first degree. But the older ages doesn't mean it won't be first degree. It could still be first degree criminal sexual conduct, still prosecuted with the same penalties.
Okay, and that clarification is important. As I said, I think we're all here to protect as many as possible at all these vulnerable ages. As you mentioned, our brains are still forming until we're in our 20s. So,
Ma'am, if I may, the current laws are 14, of course, because the age of consent is 15, right? So typically from the first degree, second, third degree, is the 14 is the cutoff. So I can understand your confusion as far as why 12, So I guess maybe that might be one of the changes, is just to make it at 14 and below, so that is consistent with the minors. And that's
So to Espasi, that was what I was getting at, is looking for consistency, especially if we're looking at one situation and then there are many other laws that are out there that maybe bit by bit we can create that consistency so that we're broadening that protection. But that was mainly what I wanted to focus on, is to try to have that consistency, to try to have that increase if it needs here or elsewhere for those other slightly older but vulnerable ages. So thanks for providing that clarification. Sujuis Masi, Madam Chair.
Thank you very much, Senator. Senator Torres, any questions for this panel?
No, I don't have any questions. I just have a comment in that I thank all of you for coming and presenting testimony, because I think that what we've got here is a situation where all factors have to be considered and weighed, including the discretion of the judges, the practicality of the issues that we're talking about, how they actually relate to Guam, the circumstances that go into deterrence, as Mr. Camacho talked, deterrence, treatment, restorative justice, all these things are relevant. And what I think is fundamental to understand is, if you look at the first degree criminal sexual conduct statute, which is 25.15 of 9 GCA, it provides for victims under the age of 14 already, and it also provides a sentence of no less than 15 years up to life. So where we can advocate for justice, I believe we've already provided for in statute. It's there. I mean, it's 15 years to life. But I think that, you know, the valid point here is that when we start to whittle away the unbiased and judicial system of weighing all the evidence and allowing justice to be rendered according to the system, I think that, you know, we perhaps are undermining the autonomy of the judiciary and the importance of keeping them and their powers intact. And that's just a statement I want to make, is that, you know, in looking at the statute, all emotions aside, I think that it more than provides for the latitude that we contemplate, and that some people would want no less than. It already contemplates that. So I just want to thank you, because I think that in all these sorts of matters, it's important to balance it, not only from an emotional point of view and from the need for justice, but also from a scientific and evidence-based perspective, which is what we rely on you experts to provide, is that scientific, evidence-based, what actually exists, what actually are the trends, and what is the reasonable expectation when we start to develop policy or change policy. So, Sizus Maasi.
Thank you, Senator. I too am thankful for your testimony and very concerned about these things, the issues that you've brought up, including, will these increased penalties deter criminal sexual conduct, which is what these bills are talking about right here, or do we need a different strategy for criminal sexual conduct for this particular crime? Will the increase in minimum sentences stop the repeat offenders that we are, of course, very upset about, or do those jeopardize our conviction of those offenders in the first place, or justice for the victim in other ways? It's clear to me that legislatures before us have wrestled with the same issues, and that they've tried to make it very clear in the statutes that young ages are vulnerable. There should be stiffer penalties, and so our statutes have done that. Whether 15 years is enough versus 25, I can't tell you. I mean, except, our initial emotional reaction, we want them locked up forever. We do not want them to repeat. We know we want that. But the courts are not imposing those types of sentences, and so you have to go back and, figure the reasons. But I do believe that the law reflects in many different areas, many different sections, this concern, and alarm for these crimes, especially for children, or against children, criminal sexual conduct against children. I think we're trying to consider also this nationwide, that they haven't determined that these increased minimum sentences are deterring criminal sexual conduct. And so, again, thank you all for your testimony, and I'll now allow the sponsor to close. Senator Luis Munoz.
Thank you very much for the panel for being here today and testifying in regards to Bill 125. I just want to state for the record that if you don't understand the degrees of the crime and the degrees of the punishment, it could really twist and turn your head. It still boggles my mind. I carry around this just to understand it, because it can be very complex if you don't understand the law. And Attorney Morrison, I understand, we're trying to separate the emotion, but it's really hard to do. This is why we're here. We're here to protect the community, and we get emotionally involved in it. It's hard not to. So I understand everyone is just doing their job, and you're asking us to allow the judges to do theirs too. And so we're doing ours, they'll do theirs too. So this is why we're all sitting here in the panel. Also want to make it clear too that we're not we're not increasing the penalties for first-degree criminal sexual conduct only for those under the age of 12. And if there's a question about the age limits, I would recommend maybe looking up Jessica's Law and see that there's a reasoning for that. And 42 other states have implemented this law already. If they have, then we should consider protecting our babies. And really, I mean, that's really what it's about. It's protecting our youngest vulnerable children, our babies. And granted, I'll still consider my 25-year-old a baby, but they're babies, really. And so I just ask, and I thank again the panel for being here. Mr. Camacho also mentioned earlier that there's something that clicks in the mind of these offenders, and they just do it. And there's no science that says that they'll be cured. There's nothing to prove that. There's a click in their head that goes off, and they do it again and again and again. So let's just keep them away from the vulnerable victims. That's my closing. Thank you, Madam Chair.
Thank you very much, Senator Muña. There being no additional individuals to present testimony, the committee will consider this Bill 125 duly heard. It is 2:50 p.m. We're going to move on to agenda item number 3, which is Bill number 97-35, sponsored by Senator James Camacho Moylan. Again, the committee's requested the feedback of the Attorney General of Guam, the Judiciary of Guam, the Guam Police Department, the Child Protective Services, Victims Advocates Reaching Out, Guam Coalition Against Sexual Assault, the Public Defender, the Guam Bar Association, and the other stakeholders on Bill number 97-35. We will now allow the sponsor to introduce the bill. Senator Moylan.
Thank you, Madam Chair. Bill number 9735 is an act to amend subsection 4010, 4020, and 4030, all of Chapter 40, Title 9, Guam Code Annotated, relative to the minimum and maximum sentences of first, second, and third degree robbery. Bill 9735 is for those convicted of robbery. The minimum sentencing will be 20 years for first degree, 15 years second degree, and 10 years for the third degree. The current law does not establish a minimum or maximum penalty for third degree robbery convictions. And with the potential plea agreements, convicted offenders may see the outside of a prison in a few years. The legislation also moves the possession of a deadly weapon during a robbery from second degree to first degree charge. Just as with Bill 96, when it comes to armed robbery charges, we need to send a strong message to criminals that enough is enough. When a victim has a gun faced at their face, even if it's just for a minute, it's a tarnished image that they will have nightmares for the rest of their lives. When these criminals rob an establishment or a home, it creates more than just a monetary loss for victims. They have taken their feelings of security away. Once again, these penalties might be considered excessive by some, or that the defendants may not be able to afford a great attorney. But is that what we tell these victims? Thank you, Madam Chair, and I'm looking forward to a healthy discussion.
Thank you very much, Senator Moylan. Is there a sign-in sheet for this bill? Sia? All right, and so we will proceed with those who want to give testimony. Could you please state your name for the record? And go ahead. Press the button, see if the red light comes on. Yes, thank you very much.
Hi, good afternoon. My name is Jesse Mendiola, just an average citizen. As I was deciding whether or not to come here to offer testimony, let me just open my phone. To offer testimony, I contemplated if it was even worth my time to come down here, whether my concerns would be heard and well received, or whether they'd fall on deaf ears. That is the kind of doubt placed not only in my mind, but that of the rest of our people. Doubt that priorities are convoluted and extreme difficulty of understanding where we lie and stand in the eyes of our lawmakers. You know, Senators, I want to tell a story, a story of a crime that occurred about 12 years ago. There was a robbery that occurred at the Hilton Hotel when an individual, a family, a mother, father, and a daughter and a stroller were walking out the Hilton Hotel. And they were robbed violently, and the lady's purse was snatched. That individual was myself. I had committed that robbery in 2007, 2008. A couple weeks later, I was arrested for robbery, criminal facilitation, guilt established by complicity, and conspiracy to commit robbery. While I was incarcerated for a week, I was arrested yet again on another robbery charge. The point I'm trying to get at here is the system was too lax on myself. I was released within 3 weeks to only go commit more crimes. And this time I did not get caught. It went years later before I finally got caught for possession charges on board an aircraft of methamphetamine and possession charges by the federal government receiving packages through the mail for methamphetamine for distribution. I served federal prison time of 3 years as well as local time at Department of Corrections. I've since been released 2 years ago, and I've been an advocate for public safety since my release. I figured that over the course of the last 23 years of my active addiction, my 4 years in recovery, it's time that I try to mend the fences in which the damages I caused. So I'm here to support this bill in particular because had there been a penalty on the third-degree felony of a robbery, most third-degree robberies are pleaded down to a theft of property. And that theft of property allows them the latitude to be given probation for a 2-year period or whatever the plea agreement may state, with credit for time served. Sadly, though, the credit for time served is not nearly as long as it should be. I believe short-term incarceration is beneficial to individuals who are abusive on methamphetamine or drug use. It will allow them to decompress, recollect their thoughts, rediscover who they are, so when they do sign that plea, and it is time served, whether it be a year or 2 years time served, they will come out with direction and with a clear path on where to head. However, it also coincides with the Department of Corrections and the programs that they have to offer over there. It's very crucial that the Department of Corrections plays a very, very crucial role in the rehabilitation of our inmates, of the people returning to society. Without the full support from the legislature for the Department of Corrections, the chances of recidivism is extremely high. My criminal record dates back to 1993 when I was 16 years old and I first got arrested for robbery. I pleaded that down and I was given a year probation. Then I've gone through the last 23 years committing crime after crime. If I had gotten caught for all the crimes I committed, I would not be a free man. I would not be a free man. So I stand here as living, breathing testimony that there is hope, that there is a chance for rehabilitation. Granted that the programs instituted are effectively handled the right way and empathy is administered across the board. We do need more programs for treatment. Treatment across the board, from sexual deviance to drug and alcohol abuse. You know, in the federal prison, the way it's handled, sexual predators are assigned a psychiatrist, and they are assigned weekly psychiatric sessions. With drug abuse, there is a program called the RDAP, the Residential Drug Abuse Program, that if taken and passed, you would get a year knocked off your sentence. I believe that federal prison helped me. It was actually the saving grace in my life. Getting sentenced, not getting probation, getting sentenced helped me change my life. And that may not work for everyone, but it definitely did work for me. So if it worked for me, then it sure as hell can work for a few. And I believe that many people out there are willing and wanting to change, however, they are just as lost as I was back in that day. And they just need the proper guidance. And that downtime that I had of 3 years in federal incarceration helped me discover the path I wanted to take when I got released. And since I've been released, I've been on nothing but wanting to help people out, help people recover, and just do the best I can to help minimize the damage that I caused. That's pretty much all I got. Thank you.
Thank you very much, Mr. Mendiola. Thank you for that testimony. Attorney Morrison, would you like to testify on this bill? Is there anyone else who would like to testify on this bill? Not, Attorney Morrison, you may proceed.
Senator, we did not submit written testimony on this bill, but I would like to provide the committee with some anecdotal evidence. Sorry, I'm used to addressing the court.
Proceed.
So I think this bill is well-intentioned, but I think there's a reality here that can't be ignored. These cases are very complicated to prosecute because they involve a fact pattern that continues on and on. Generally, what I've seen is these types of purse snatching robberies or armed robberies. The victim is usually a tourist. The victim's usually gone by the time trial comes along. There's usually more than one defendant, so it becomes a process of the government being in a position where they may have to dismiss the case unless one of the co-defendants agrees to cooperate against the other. Typically what would happen in that sort of a situation is the cooperating witness may get the benefit of pleading their case to a third-degree robbery that doesn't require mandatory minimum jail time. I think that if their conviction was going to require mandatory minimum jail time, I think the courts could expect to see fewer cooperating witnesses in those sorts of cases and more situations where the case would just have to be dismissed outright. That's my personal view of it. I have been able to negotiate those sorts of cooperation agreements in the past, and the cooperation of my clients was very important in making the government's cases in those instances. I would also say that I think that, similar to some of the previous bills, some of the considerations in sentencing are already taken into effect based on the current law. Currently, there are sentencing enhancements for a dangerous weapon, a vulnerable victim, committing a felony while on felony release. All those things combined could easily result in a life sentence if the situation mandated the most extreme consequences. The sentence enhancement for felon on felony release is 5 to 25 years. Sentencing enhancement for dangerous weapon is 5 to 25 years. Vulnerable victim is 3 to 5 years, and that's in addition to the base sentence. So there's already the possibility of just an extreme sentence if the government's case is strong and their witnesses are available and they're able to put on their case. I would say also that this takes out some of the consideration that I've spoken to. Generally, there's 2 or more defendants. Generally, one is a much younger person, and generally the other person is older and is influencing that person to commit the bad behavior. I think these sorts of sentences would take it away from the judges to consider the age of the defendant in those cases, and I think that's an important consideration. Those are my comments.
Thank you very much. Any questions for this panel by the senators? Senator Rangel.
Thank you, Madam Chair. I just wanted to speak with Mr. Mendiola. First of all, I'd like to commend you for coming out and testifying. It takes a lot for a person to acknowledge their past mistakes, acknowledge and accept their wrongdoing, and especially in public. So I commend you for that.
Thank you.
I have some questions along the lines
sure.
of your testimony. You said you served time.
Yes.
How long did you serve?
I served 3 years in federal prison and just about 2 years in Department of Corrections.
So about 5 years?
Yeah.
And you didn't serve any time for those burglary cases, is that
No.
right?
My first arrest in 1993 for robbery, I was just given a plea agreement of 2 years probation. I completed that. I was charged as an adult, though I was a minor. Then once I got off probation, I committed another crime, theft of property. I was given probation yet again. And then once I got off probation, I committed another crime. The problems with that is all my arrests were stacking one on top of the other. There was no accountability there. Had they been harsher on me back then, who knows the path I would have taken. It would have allowed me further insight, to gain insight at an earlier age than it did later. It wasn't until my freedom was slowly taken away from me that I actually contemplated about my life and where I was headed. Because I'm 43 years old. I got released at 41, and I wasn't about to be 50 years old doing the same thing. So I made that change, and if I can just stop the youth from continuing down that path, then that's a win for me. I may not be able to change the current adults doing their things, but if I can help out the youth and bottleneck it there, then they have a chance of of living a better life than what it currently is. Because the only way to move forward is to break the, we already broke from tradition because we are not culturally what we used to be. So we need, if we're going to redefine that, then we got to redefine everything. And it all starts with our youth. We can treat the adults, the addicts, but focusing a lot of energy in educating the youth, providing them programs, instilling values, then that would further deter them from graduating into a life of crime.
Thank you. So you served about 5 years time,
5
you
years,
said?
yes.
And in that 5 years, you feel that it did a lot of good for you and helped to rehabilitate you?
Well, the 3 years straight did a lot for me. The 5 years, the 2 years broken up did nothing for me. All it did was allow me detox time. That's all it did. Time for drugs to get out of my system, for me to sleep up for 2 months and then get out.
So during those 3 years, you received some form of drug treatment?
Yes, I did. I received a 40-hour drug treatment class that was offered by the federal prison, and I also took various other courses in there, business management classes and family education classes. I believe if the Department of Corrections and the University of Guam partner with each other to offer inmates college courses, that could help them have light at the end of the tunnel.
Thank you. And the reason I'm asking those questions is because this bill itself, with the mandatory sentence it places in here, is a term of no less than 10 years. So what I'm hearing here is, had you been convicted of that crime for burglary, if this law was in effect, you would be in for 10 years.
Yes.
Instead, you got out in 3 years, and you say you're a changed man now because of the rehabilitative services. Is that correct?
Yes, sir. But my 3 years incarceration wasn't due to a robbery offense. It was due to an importation of methamphetamine and drug distribution. So that was my robbery offense. I was only given probation.
I guess what I'm saying is it sounds like you served less time for that than you would have under this proposed bill.
Yes.
This proposed bill would do 10 years.
Yes.
You're saying it only took 3 years to change your life.
Well, I would think that 10 years would suffice if the individual themselves has an extensive criminal history. If the criminal history is to a minimal, but also it depends on the level of violence committed in the crime. And if there were any, if it was a nonviolent crime, then I beg to differ. But then if it was a violent crime, then 10 years would suffice.
Okay, thank you.
Thank you.
But I think one of the biggest things that you seem to be pointing to is the rehabilitation.
Yes.
Right?
Rehabilitation. It allows, incarceration allows people time to.
If we do rehabilitation
if they
during
do
the
rehabilitation,
incarceration.
it's counterproductive that if there is no rehabilitation at the Department of Correction, it's counterproductive. Now you're just housing them. Now it's
Right.
just a warehouse.
That kind of matches what the director of DOC, Director Izaki, stated earlier.
Yes.
So the reason I'm asking these questions is because, while we do want to be tough on crime, absolutely, and we need people to understand that there has to be consequences for actions, and you need to be punished. But at the same time, we also have to keep in mind that if we house people, as you're saying, without rehabilitating them, then what we create is a revolving door effect.
Well, the revolving door it's obvious right now. It's obvious. Day in, day out, you read the paper, people are constantly getting arrested, getting released, getting arrested again for the same crime weeks later. So the revolving door is already out. You get arrested, you go in there. If you don't have bail, stay in there. Figure yourself out. Figure yourself out. A lot of people get released on personal recognizance, and it just gives them the latitude. I'm going to tell you the truth. I thought the system was a joke. I cheated the system time and time again. Most of all, I cheated myself. That was the main thing. I tried to dance around the system while on probation, going there with fake urine to pass a piss test and all the, going on the run. So if the system was harsher on me at a younger age, perhaps I would not have gone down this path. And perhaps another victim would not have been robbed. Because like I said, if I had got caught for all the crimes I've done, I would not be here.
Do you think if you had got 10 years at that first crime that you committed that you mentioned, had you done 10 years and not received any sort of rehabilitative services, where do you think you'd be now?
I would be lost because a lot of people leave prison with no direction. Families pass on while you're incarcerated. Times change. Time does not stand still while you're in there. People's lives move on. So when you get out, you are getting out to the unknown. And the definition of fear, in my personal opinion, is the unknown. So for me to come out to not knowing what I'm going to get or expect, it's going to throw me back into the very same comfort zone that I've been all those many years, which is the people and the places and things that led me to where I was currently at.
Thank you, Mr. Mendiola. And thank you very much again for your honest and open testimony today. Thank you.
Thank you. You're welcome.
Thank you, Madam Chair.
Thank you very much, Senator Rajel. Senator Taitukwi.
Sidus Masi, Madam Chair, and Mr. Mendiola, you know, you're not alone. There are people out there who, especially families who are affected, who have family members who've been
Yes.
affected by this. You know,
Yes.
I had a family member who was in that situation, and it was in and out of jail as well. And it was very difficult. And I think that if she had stayed in jail, she could have, with some rehabilitation, by the way. I mean, you mentioned earlier to my colleague here that you wouldn't know where you'd be in 10 years if you were there, family coming and going. That's true if you had no rehabilitation. But in that 10 years, if you had been in there for 10 years and had the rehabilitation, coming out today, let's say after 10 years, I'm pretty sure that you would be who you are today.
Yes.
It takes a strong individual to only allow 3 years to be where you are today. That's a very strong person, and it reflects that because you're here today testifying, being honest about what happened to you and sharing your circumstances with us as well as the public that's listening. And I just want to commend you for that.
Thank
and
you.
let you know that you're not alone. Everything that you said, I'm really taking to heart. And I think that having the director of DOC here, I'm sure what you said is taking him to heart too, as well as he mentioned earlier on rehabilitation. So once again, what I said about being, let's say you were in jail for 10 years and you had the rehabilitation, let's change that question around to, if you had rehabilitation, do you think today you would come out to be the man you are today?
Yes. If I had the rehabilitation?
Yeah.
Definitely.
In 10 years?
In 10 years, definitely.
Okay.
Because you have one thing people fail to realize, 10 years goes by fast. So the first 5 years, you could use that to rehabilitate yourself, accumulate degrees, certificates, work within the prison system. I worked in the maintenance department. I got paid 19 cents an hour. I was excited, 19 cents an hour, and I was a plumber within the prison system. So it ran effectively like a society. It was a mini society. The prisoners ran the prison. They cooked, they fed, they made blankets, they did everything, the commissary, everything was there. It allowed them to feel some sense of normalcy from behind the walls. And it allowed them to have structure, routine, and consistency. So once you have those things in place and you're released, you can live a pretty decent life if you have structure, routine, and consistency with the plan behind that. So you can go execute that plan once you're released. And mind you, when you get released from federal prison, you're not released broke. Some inmates, I know somebody who was released with $10,000 in their prison account. That was $10,000 accumulated over the years from his job at working for Unicor, which paid him about $150 a month. So there are so many different variables and different options that they have that could help a person rehabilitate. It's just a matter of implementing them and running them effectively and putting the right people in place. Because it's not a game, it's people's lives. We want these individuals to come out to society rehabilitated. We want them to be given that second chance. We don't want them to commit the same crime that they've done before and go back in and become another statistic. If they're going to become a statistic, let them become a statistic of success. Then that's what I think.
So you're saying the first 5 years is to find yourself, to find your own rehabilitation, and the next 5 years would have been to seek the help and open mind, to have that open mind now and clear-headedness to get the rehabilitation thereafter, So,
Well, it also goes back to counselors and case managers. It's very important that the prison system is adequately staffed with case managers, because the closer you get to your release date, the more and more you will see your case manager. I saw my case manager once every quarter for the first year. After that first year, it was already getting closer to home. He said, okay, we got to get you ready for home. I was like, already? That's too fast. So I started to see him every month. So your case manager is very crucial in ensuring that the steps are laid and the foundation is laid for you to walk out.
thank you so much, and again,
you.
appreciate your testimony here
Thank you.
this afternoon. Thank you.
Thank you, Senator Taitigui. Senator Torres? Senator Kelly Marsh Taitino?
Sejus Maasi, Madam Chair. So, trying to think in my mind where to start. But I just want to mention, I know I mentioned it before, with the legislative intent, where one case study for one state with particular circumstances is used in a blanket way. So that needs to be corrected here, because it can't adequately justify in a blanket way all situations, and especially as it's been noted, I mean, these things are very complex and there are a lot of variables involved, and we're actually still, as a society, sorting out what works best. I mean, I think this will be an unending journey, because society always changes, factors always evolve, and so forth. But let me get back to my questions and comments. I also, Mr. Mendiola, really appreciate your coming here and testifying today. You know,
Thank you.
I've also known other people that have turned their lives around, and I really appreciate and admire what they do. Those that go out there and try and make a difference, try and help others, learn from their example, and advocate for what they can.
Yes.
So I do thank you for that. I did have a question, and perhaps the public defender, the person, Mr. Morrison, Attorney Morrison from the Public Defender's Office can provide this. So in reading through some of the background here and looking at what exists in other states and so forth, it seems that in other states there's really quite a range of approaches for length of time and so forth to this. So it's not necessarily set in stone, but we have to figure out what works for Guam. That's most important. Do we have aggravated robbery? That was something that I ran across, where in order to get into these stiffer level of penalties, they were saying there was a distinction, at least in some states, between robbery and aggravated robbery. Do we have that distinction here, or is it just kind of spelled out by the different degrees?
Senator, it's spelled out by different degrees. The closest thing we would have is first-degree robbery that's currently Chapter 4010. The penalty for that reads, robbery in the first degree is a felony in the first degree. In case of robbery in the first degree, the court shall impose a sentence of imprisonment of a minimum of 10 and may impose a maximum of 25. The minimum term shall not be suspended nor probation imposed in lieu of minimum term. It goes on to that. But this is in addition to the aggravating circumstances that can be pled, such as felony on felony release, which is another 5 to 25 year enhancement, and use of a deadly weapon in the commission of the robbery, which is another 5 to 25 year enhancement, and there are several other enhancements that would open someone up for a much longer sentence. So that's the law as it currently stands. And then there's second and third degree robbery. Third degree robbery can allow for a probationary sentence, but as I tried to point out earlier, I think there are good reasons for that in some cases, particularly cooperation incentives for defendants.
Sujus Masi for clarifying those couple of points, because part of this bill is to create something more firm, I guess would be the way to describe it, for the third degree, and maybe would take away some flexibility or some consideration where the minimum term then becomes 10 years and a maximum term of 20. And so perhaps you see some reasoning. I'm very curious about the reasoning where for the first degree it doubles, which is quite a step up. But in the second degree robbery, it triples. And then, well, in the third degree, it creates an entirely new situation here. I know that you've testified and talked about the years of terms, and we've talked about rehabilitation and so forth, but do you see a reasoning that you can explain as to why it doubles in one instance and triples in another and creates a brand new category, or to speak to it in any fashion?
Senator, that may be a better question for the bill's sponsor. I don't know what the distinction, I don't know what the factors were, but what I would say is that I'd be hard-pressed to find a situation where, at least as far as I'm concerned, the government wouldn't charge first degree, because I believe they would always allege that someone attempted to inflict serious bodily injury, and that's the attempt is all that's required for that statute.
And because a lot of these laws have similarities, I've addressed some of my thinking as I went through them about whether they made sense in the bigger picture, because of course, at least in the way that I was reading through them, I wanted to see that the big picture still made sense altogether, and so forth. So, yeah, I guess I'll just end on saying that in various studies that are out there, I mean, it's true that there are still quite a few studies, and it seems like it's still being calculated out, the true situation here. I mean, because what we want is, we want real results. We want real changes. We need this for our community. I guess the other thing that struck to me in going through this is maybe also understanding for our community. They were saying that in some of these studies, for the community, it was making sure that they're curbing the recidivism, that was the most important point. And so we've had some discussion about that the rehabilitation seems to, from this hearing and other hearings that we've had, the rehabilitation really seems to make a difference. And it seems to be also the direction that the courts are going into, having more rehabilitative sentencing and courts. But it'd be important to hear, I think, from our community as well, if that's the most important concern, is recidivism, because that gives us a real focus then on how to get there. So, but thank you again for your input.
Thank you, Senator. I want to point out that according again to BBMR, we have a fiscal note that says that this bill is administrative in nature and there's no fiscal impact seen. Of course, when you get into the discussion of rehab versus just imprisonment, which the bill talks about, it's a whole other discussion, and that is not being discussed in this bill at all, unfortunately, because increasing prison terms without any rehab, the DOC director has testified, is pretty much a formula for a bigger disaster, more recidivism and less success in any way. But we've also received recommendations from the Legal Bureau, which discuss I had asked them about the legislature's purview to increase sentences, if that has any constitutional implications, and she said such mandatory minimum sentences are probably not cruel and unusual punishments or grossly disproportionate to the offense, which I had asked, because outside the context of capital punishment, successful challenges to the proportionality of particular sentences have been exceedingly rare. She does recommend, and so she says it's not considered unconstitutional under the Eighth Amendment, and that it is within the purview of the legislature to set minimum sentences. The Legal Bureau also says, or also recommends revising the legislative intent section to include citations to statistics, articles, and other factual information to lend credibility to the bill's purpose and substantiate claims made. All right, so I'm going to go now to the sponsor of the bill for closing remarks. Senator Moylan.
Thank you, Madam Chair. Bill 9735 is about sending a stronger message that needs to be sent out to the offenders when it comes to illegal activities. Our small island community is seeing a rash of robberies, especially with criminals bearing deadly weapons and stirring fear in island residents, which is a situation would scare any individual for life. Many public safety experts relate the increase of robberies with the rise in a drug epidemic. Thus, it is vital that longer sentences be equipped with opportunities to seek professional help for those with drug addiction, to provide them a chance to live productively upon their release. While stiffer penalties and sentences will result in both an increase of prisoners at Department of Corrections, along with additional costs, the safety of our community is paramount. Criminal reform and reducing recidivism needs to continue to be a key objective of the government. However, just as important is assuring that shorter sentences don't result in the convicted individual committing a similar crime again upon release. When our island residents are getting robbed at work, parking lots, or even in their cars, this means that the government needs to do more. Our government needs to send a strong message in that enough is enough, which is the reason we have begun this process to stiffen penalties associated with certain crimes, because we owe at least this much to the victims of such heinous crimes. Thank you, Madam Chair.
Thank you very much, Senator Moylan. There being no additional testimony on Bill 97, the committee will consider this bill duly heard. It is 2:25 p.m. and we were going to move on, and we're going to skip the fourth agenda temporarily and go to the fifth agenda because there are many people waiting for that fifth bill, and I apologize for the wait. So we're going to move to that bill right now, and fifth agenda item is Bill number 98. This bill was introduced by Senator James Camacho Moylan, so I will ask him to introduce the bill.
Thank you, Madam Chair. Bill 9834 is an act to add subsection 7044.4 to Article 1, Chapter 70 of Title 9, Guam Code Annotated, relative to the penalties associated with crimes against tourists. Bill 9835 would establish that those convicted of crimes against tourists, that their minimum sentencing be equivalent to the maximum sentencing established by law for that conviction. With tourism being an economic engine of our island, any crime against visitors is essentially a crime against the community. Hence, a stringent policy must be established. Now, there are those who have stated that this legislation creates a unique class of tourists when it comes to how criminals who commit crimes against them are treated. The reality is that our criminal codes in general need to be overhauled, and this legislation merely recognizes that when criminals commit a crime against a visitor, that defendant would literally be facing two charges. One for the crime they committed, and secondly, for the economic impact that the crime would have with tourist industry. A crime that affects all of us. Bill 98 sends a strong message to these perpetrators. There are those that have stated stiffer penalties may not deter the active criminal activity in our tourism district. We agree that more must be done, and we are working on other measures to ensure uniform presence. But it is vital that recognizing that crimes against tourists is indeed a plaguing problem, and that solutions need to be brought to the table for discussions. Thank you, Madam Chair. We look forward to a healthy dialogue on this issue.
Thank you very much. We have several people signed up to testify. If you could please come forward. John Morrison from the Public Defender's Office, Milton Morinaga from Guam Visitors Bureau, Bobby Alvarez, Guam Visitors Bureau, Paul Suba from former police chief, Terry Chung from KGTA. And before we proceed, I'd like to also put into the record that the committee has requested the feedback of the Attorney General of Guam, the Judiciary of Guam, the Guam Police Department, Child Protective Services, victims advocates reaching out, Guam Coalition Against Sexual Assault, Public Defender, Guam Bar Association, and other stakeholders on Bill number 98-35. According to BBMR, the bill is administrative in nature and has no fiscal impact to the government of Guam. According to the Legal Bureau, there are several recommendations were made. She notes that this bill may conflict with the current law, the Vulnerable Victims Statute, which also covers most, if not all, crimes committed against tourists or visitors. Because both this bill and the Vulnerable Victims Statute cover crimes against tourists, it arguably would provide the court with an option between two sentencing schemes. One option imposes a maximum sentence with no suspension of the same, and the other option does not require such disposition. Having these options could lead to the unequal application of sentencing. Again, per the Legal Bureau, if the intent is to impose a mandatory maximum sentence with no option to suspend a sentence for all crimes committed against tourists, we recommend revising the bill or introducing a new bill to amend 9 GCA 80.37.3 by deleting the definition of tourist or visitor and placing the same in a new section, and then impose a mandatory sentence with no option to suspend. There are other recommendations made by the Legal Bureau, including consideration of including attempted crimes, which is currently covered by the Vulnerable Victims Statute, but not by this bill, and other technical suggestions that are made. So we will now proceed. So Attorney Morrison, if you would like to proceed, you signed up first, or would you like to go?
That'd be fine, Senator.
Thank you.
Our director from the Public Defender Service Corporation submitted written testimony on this matter. I think that largely sums up our statement that there's effectively already a statute on our books that addresses this exact issue, and we don't feel that a change in the law is necessary as a result of that.
Thank you very much. Mr. Morinaga? Please state your name for the record and turn the microphone.
For the record, my name is Milton Morinaga. I'm the Vice Chairman of the Board for the GVB. Good afternoon. Thank you very much for giving me an opportunity to speak on behalf of GVB. I have the Vice President, Bobby Alvarez, to speak out on a written statement from the President of GVB. But I just want to make a point that there's a lot of destinations that had negative image of not being safe. And our mission as GVB is to send out a message to the people, tourists, that this is a safe destination, that we would not tolerate any violent crime against them, nor the residents of the Guam people. And we would like to do that. One time, last year, there was a message out from one of the Consul General sending a message on the paper saying, please do not leave the hotel after 10 o'clock because there's a rage of crime in Tumon. That kind of message is not wanted. And I do not appreciate that kind of message to be sent out. So, yes, we all should be always aware of what's around you, I understand, and safety is responsible of each individual too. But as a government entity, and as a tourist bureau, we have a responsibility to help make sure that they have a place to come that is safe. And I would like to support that message that, that our message is that this destination is a safe place to come. So I support this motion.
Thank you very much,
bill.
Mr. Moranaga.
Thank you.
Mr. Alvarez.
Yes, Bobby Alvarez from the Guam Visitors Bureau. Thank you for having me today to speak out on behalf of GVB. Hafaday Senator Terlaje and members of the 35th Guam Legislature. Thank you for the opportunity to submit testimony on Bill number 9835 relative to penalties associated with the crimes against tourists. As a public non-stock and nonprofit membership corporation that represents the island's tourism industry, the Guam Visitors Bureau's mission is to efficiently and effectively promote and develop Guam as a safe and satisfying destination for visitors and to derive maximum benefits for the people of Guam. With over 1.5 million visitors welcomed annually to our home, we take great pride in making the island a better place to live, work, and visit. We also broke a new record with Guam welcoming over 1.63 million visitors to our shores in fiscal year 2019. That's a lot of targets out there if you think about it, right? Tourism is the largest single private sector contributor to Guam's economy, representing $1.2 billion annually in island revenues and supporting approximately a third of the island's employment. GVB has a vested interest in protecting and ensuring the safety and security of all visitors. Our exit surveys indicate that safety is a top travel motivator amongst all of Guam's source markets. Crimes against tourists have a negative impact on our number one industry because it threatens our image as a family-friendly destination. GVB supports all initiatives that protect our tourism industry and the intent of this legislation. We take pride in promoting our island paradise as a family-friendly and safe destination. Sidus Masi for your support of Guam's tourism industry. Thank you.
Thank you very much, Mr. Alvarez. Chief Suba?
Hafaday and good afternoon. My name is Paul Suba, former Chief of Police of the Guam Police Department. More importantly, I grew up here on Guam. And in my growing up, I saw that crime was affecting innocent people. It really escalated after the Vietnam War when heroin hit the island right between the eyes, and people just couldn't believe that our own people would victimize our families and our homes and turn this beautiful island into something we didn't recognize. Based on that and many other reasons, I decided to join the Guam Police Department to do my part to see what we could do together with my brothers and sisters from the island to protect our community. Having done that for 40 years, even working in Oregon as a deputy sheriff, I saw the situations that many of the other speakers have spoken about, including Mr. Mendiola, who I really appreciate coming forward. Growing up in the department, and these things I'm saying all correlate to the bills that you presented earlier. They're all connected to include the tourism situation. I looked at, with many of my colleagues, we looked at the records, the arrest records of these folks. And many of them, if they were caught at all, many of their cases would fall through the cracks. You'd see time and time after case of arrest, no prosecution, prosecution decline, this, that, or the other. By the time they finally got any attention, they had committed murder in many of the cases, or aggravated assault, or aggravated robbery and rape. And so as time went on, we even changed the language. We don't longer call it rape, we call it criminal sexual conduct. Let's tone it down a little bit because the word rape is too devastating to the victim and maybe even to the responsible. So all that said, when Frank Ishizaki was the chief, we worked hard to build new precincts, one in particular down in Tumon. And the reason for the Tumon precinct in particular was because the only real industry we have on Guam for our economy to prosper and for everyone here to have a good job is tourism. And so the precinct was placed in Tumon. The problem is that over the years, we've kind of gotten away from that perspective. And Tumon now, the precinct there, is just another precinct to help contain or control or arrest in other vicinities outside of Tumon in most cases. They'll be called to Tamuning, which is a big village, Harmon, and other areas. And it's part of the problem because there's no prevention. And as I look back, prevention has always been the key to many of these issues. Otherwise, we wouldn't be sitting here today to look for other answers to the criminal issue. And that means deterrence through punishment or incarceration. And hopefully at some point in our history, we will see really what is the name of the place? Department of Corrections, a correctional facility of sorts, so that people truly will not be recidivists. But there's recidivism because too many times they're not caught, and it goes back to there's not enough enforcement. And so when my good friend Frank, the former chief, former senator, now acting director of DOC, said that more police means more arrests, well, it not only means more arrests, but that means that there will be more officers, hopefully, to do prevention so that there won't be people arrested. And then the other part of this whole, it has to be multi-pronged. It can't just be looking at the most serious crimes and serious punishment. And that's a whole big discussion I know we're not here for today. But multi-pronged, when I say that, educationally, all of our discussion here, and we all understand, and you even said it, Madam Chairman, that you have to really understand the degree and what goes along with that and why is it that way. A lot of those people out there that are committing the crimes don't bother to read the paper, they can't read the paper, they don't care about the paper, or what have you. They're involved in drugs or alcohol, they came from abused families, they're abusing each other, they're abused themselves, they grew up to be pedophiles because they were abused as a child. You're absolutely right. So I say education is going to have to be at the forefront, not only in our schools, so that whatever comes out of this legislature and is law, that it gets to those kids at their age in their schools, at the middle school and high school ages, and definitely college, to understand the law and what are the ramifications and consequences. And then the other thing is that we need to have more patrolling. The late Governor Berdalio, he initiated the true neighborhood patrol. We talk about neighborhood patrol today, but I don't see the reality of a real neighborhood patrol. And I compliment, I admire, and I respect the governor and the lieutenant governor and their platform to have a better public safety system, and I agree with that, and I think everyone's working hard to do that. But the real neighborhood patrol actually went out to individuals to help them to prevent their own victimization by giving them information on how to better protect themselves, not to give the criminal the opportunity, because we are all at fault at some part in the whole system of things. If I leave my cell phone here, I trust my good friend here, he's not going to touch it, but somebody else might, and then I got to file a complaint, and on it goes. So education and neighborhood watch patrol, supported of course by the community. You know, tourism, I understand, and I've seen it since I've been working with GVB and in the Tumon area. When we say crimes against the tourist and how it affects everyone, way back we used to, at the top of a police report in bold red letters, indicate crime against tourists, so that when the Attorney General gets the report, their focus is on it in this manner, where these types of consequences can be brought forward and discussed with the court, with the defense, with the judge. That isn't being done right now. The other thing is, crimes against tourists should include open lewdness, public intoxication, anything that affects the tourist industry, but also our children. We're all connected in this. There are people that are exposing themselves. They don't get caught or arrested until they're here on social media and somebody says something. And then the media says what's being done. So those kinds of things we've discussed amongst the leadership with the police department, that those kinds of emphasis have to be brought back again. You cannot just allow somebody to urinate right there by the bus stop with a bunch of tourists that we have invited to this island and said, look, Guam is beautiful, come and enjoy it. Yes, all the money you spent is worth your while here. And then there's an individual right there by the bus stop, urinating, harassing, asking, begging, challenging for money to go into the next store to buy more alcohol to come back and do it again. Now, I appreciate and I applaud the GVB because of the visitor safety program that you now see is expanded to Agani. I'm part of that. And I have to say it's made a big difference because although we're short on law enforcement, those folks actually encounter and engage with these individuals that are committing the crime I just explained, and trying to get the assistance from not only the department, but mental health and substance abuse, and our brothers and sisters from the other islands, because many of them come here and they don't understand what the laws are, and they have to be helped before they come to the island. Not only about alcohol and open lewdness, and I'm not saying that's the group, it's everyone actually that thinks they can get away with it. But that also helps with regard to criminal sexual conduct and the abuse and mistreatment of children. And I have to tell you, in 40 years, I don't know why I'm still here. But thank you.
Thank you very much, Chief. Mr. Alvarez.
Just to add on to Chief Suba's remarks, you know, we have to look at safety of the tourists, right, as a whole. Like, we got to understand that's someone's mother, that's someone's daughter, that's someone's father or someone's kid. And just think about it, if we were to send our parents or our kids traveling, what would you expect in terms of safety for them in that country? So I think this is good legislation, and repercussions are going to be part of the education for it, and I think it's something that's going to support the safety of our tourists, and that's another way to really look at it as a whole. So thank you.
Thank you very much. Mr. Chung, could you please state your name for the record? And
Half a day, Madam Chair and Senators. My name is Therese. I am the newly elected president of Korea Guam Travel Association. I've been in travel industry in Guam for many years. As choice for travelers, Guam have many advantages to other destinations in Asia and Southeast Asia. Safety is one of those advantages. It is an important advantage. The image of Guam as a safe place for single, young family, senior citizen, and corporate incentive traveler is a key component to the success of our visitor industry, particularly in Korean and Japanese market. As chairman of KGTA, we are especially sensitive to ups and downs of our tourism market. And yes, even a single crime can and does make it harder for business to sell our island abroad. In an age when news spread instantly via internet and when competition with other destinations is especially fierce, a single incident in which a tourist is mugged, robbed, injured, or otherwise suffer at the hand of a criminal is particularly damaging to the image of Guam as a safe place to visit. Today, with all social media, any negative incident can spread out and share immediately. That's why it is very important to keep and protect our number one industry, which is tourism. The increase in Korean visitors to the past several years has been very good for our island, our economy, and the people of Guam. But corresponding increase in crime that our island has experienced during the same time is a threat to the sustainability of those hard-fought and won gains in our visitor arrivals. I've lived in Guam for 15 years and raised my family here. My family and I have seen the changes that have taken place on our island and its concerns. Not just because tourism is the livelihood by which I support my family, but because this is our home. Crime, whether it is against our families or tourists, diminish the quality of life for all of us, but there is an additional hidden cost to our visitor industry in particular and the broader economy in general. For all this reason, I support Bill 98-35.
Mr. Chung. So we will proceed with questions from the panel. Thank you to all of you for your testimonies. So Senator Rigel.
Thank you, Madam Chair. My question is for Mr. Morrison from the Public Defender. In the testimony, and I know it's actually written by Stephen Hattori, but in the testimony, and you kind of mentioned it a little bit, you said that there's already a vulnerable victim sentencing enhancement. And then in the testimony here, it says the enhancement already gives the sentencing judge discretion to sentence the defendant to a term of imprisonment of not less than 5 and no more than 25 years, right? So it sounds like that's a minimum, mandatory minimum of 5, maximum 25.
That's right.
And then,
Excuse me, but that's in addition to the regular sentence for whatever crime it is.
That's right. If it were a robbery, which is frequently the case, then the sentencing requirements for the robbery that I mentioned earlier would take place. 10 to 25 for a first degree, and it goes down from there. But the sentencing enhancement is absolutely in addition to any other sentence that they receive.
thank you for that clarification. So, for example, someone got convicted of robbery and say they got 10 years for robbery. Then, if it was considered a vulnerable victim, then they would get between 5 to 25 on top of that.
In
right?
addition, that's right. Yes.
Okay. So, my question is with regards to this proposed legislation. It says here that any offense against a tourist or the property of a tourist shall be sentenced to serve no less than the maximum term of imprisonment, which may be otherwise imposed upon conviction of said offense. So, for example, if someone robbed a tourist and they got first-degree robbery, how do you read this bill? What would it require? What would it turn the minimum into? It sounds like it's turning the maximum into the minimum.
For first-degree robbery, for instance, the mandatory minimum, if that bill were read in that fashion, would be 25 years.
So first-degree robbery of a tourist would be 25 years. If this bill, the way that this proposed bill reads.
I believe that's what's anticipated, yes.
But then on top of that, there could be an additional 5 to 25 under the vulnerable victims enhancement?
Well, that's potentially one of the issues that I think the legislature is going to run into here, is that there'd be a need to not, there'd be a need to be really clear about whether or not the sentencing enhancement was going to apply in addition to this or operate independently.
Okay, thanks. That's what I was trying to determine. So we need to clarify how that would work. We need to get a better understanding of how that works. Otherwise, it could be someone for first-degree robbery of a tourist could get 25 years under this because that's the maximum term of imprisonment for first-degree robbery. And then on top of that, we have to question whether or not they would be a vulnerable victim enhancement, which could lead to another 20. So it could be 50 years for first-degree robbery.
That's absolutely right.
If that's how these laws work together. We have to determine if that's how the laws would work together, is what you're saying, right?
Yes.
Thank you. Thank you, Madam Chair.
Thank you, Mr.
No further questions.
Senator Rigel. That is also the recommendation of our legal bureau, is that there's a conflict and we need to resolve that, exactly what you described. All right, Senator Taitigui.
Thank you. I just wanted to, Madam Chair, thank you everyone for being here. You know that GVB is very dear to my heart, and I appreciate that you're advocating for, more safety within Tumon as well as the other areas. You talk about Tumon a lot, but you got to remember, there's a lot of people going to Study Bay, and now that Agana, and I'm glad that the VSO's out there and protecting that area. There's some conflict here. I pulled up the law that Senator Brant McCready had introduced back in, I think it was the 32nd Guam legislature, called the, and made reference to the tourists. But, I was hoping that Bobby and you as well, Paul, that I've been in contact with the chief of police for almost a week and a half. Every single day my office is called regarding cameras. $250,000 was given to them last year to put up these cameras. It seems to help. And my question to you, Mr. Morrison, these cameras catching these individuals like purse snatching and things like that, is that very helpful? When I know you're a defense attorney, you know, it's kind of ironic. We're sitting here today asking the questions from a defense attorney, you know, in the first place. But I'm pretty sure once you get something on camera and showing the individual in the act, you know, it's pretty hard to, you know, not prosecute him, or not prosecute, but what's the word I'm looking for? Basically, not condemning him, but, you know, convicting him. Thank you. It's been a long day, Senator. Convict him, you know, these cameras. So I think more of that needs to be done with GVB, you know, investing in more cameras out there. It deters people from doing anything. It makes them think twice, you know, thinking if they can get away with it. And so I just wanted to make that comment, you know, to please look into those cameras and work with the chief of police currently, who has $250,000 right now under their belt. So greatly appreciate you being here today and testifying. Thank you.
Senator, if I could say that,
yes.
that high-quality video is very helpful to the prosecution of cases, and it's something that I can go over with my clients when I have them, and go over the quality of the video is something that I'd be very cautious of, because it needs to be high quality to have the right effect. But that and an additional police presence, I think, are better deterrents than this proposed bill. Thank you.
No, and thank you for that comment. And I think the others heard that as well. Quality cameras, okay, gentlemen. Thank you.
Thank you, Senator. Senator Marsh-Teitzino?
Therese, Madam Chair. In looking at this, definitely I understand the intent, and I understand the discussion about the impacts to our industry and our image and all of that. And of course, to be balanced with everything, or maybe not balanced, balanced isn't the right word, but to make sure that we're continuing to include is the safety. I mean, we care about our children and our community and all of that as well, of course. So all along I've been trying to keep all of that in my mind for that really big picture and how to think of it. And so the written testimony from the Public Defender's Office is very important, that it's felt to not be necessary. And in looking at the definition of a tourist here, it's more narrow than what's in the vulnerable victims section of the Guam Code Annotated. It's in the Guam Code Annotated? Okay, sorry, this is still a field I don't delve into that often. We have a variety of tourists, and so, you know, what was going through my mind in the way that in my realm of field of study, we talk about tourism, we talk about those that attend conferences, those conducting research, those that are out carrying out sports training and things, and you know, coming out here for pleasure and so forth. I don't think that really captures it, and maybe even in the vulnerable victims, maybe that could even be looked at to update ourselves with the way that we know how to look at tourism nowadays. Even people who come out here for training, they're providing a certain type of tourism. I mean, there are many, many ways to look at it. And then I also tend to start thinking about the others that are involved. And so in this case, like with tourism, of course, we value our tourists, we value our community members, but it doesn't include those within the tourism industry who are still a part of making our tourism industry function. And so they fall out of this. That worker who goes to work at 4 a.m. in the morning to do presumably his best service or her best service for our tourism industry, it doesn't include them. So anyway, with that aside, I really like what we've been talking about. I'm very much a proponent for proactivity. So the education, the other approaches, the high quality video, the additional police presence, making sure that we're working on prevention, those multi-pronged approaches, that's definitely where I come from in social science. It always has to be a multi-pronged approach. So I think that this is an opportunity to discuss that we really need to look at those areas and see how we can be building them up so that we are getting to what we want. We want safer tourists. We want our safer community. We want additional safety for our children that are in schools and at the bus stops. I mean, we want that additional safety for all of us. I do really want to commend GVB with now I tried looking it up, the best I came up with, but I'm sure I heard of other terms that were catchier than yellow safety officers. But with that safety program that they rolled out and then using that sort of social science brain of mine and the way that I think, just thinking about, they give us more. They give us safety, increased safety. The crime rate, as it was discussed in the newspapers, is thought to have gone down now that their presence is there. But they're visible. They provide a pleasant experience. They can do other things, like they provide directions. They can move around to meet different needs. So during Golden Week, they had moved around the island. It's creating employment so that we have more salaries. So there's more government costs to having more employees, but we're also providing jobs. So they will pay taxes. They will be spending money. So I think that there are these more complex ways that we can be looking to solve these issues as well, that we're tackling safety. There was that, and I really appreciated hearing the history, Mr. Suva, of the precinct in Tumon. It sounds like it's changed a bit over the years, but in talking about it, this maybe is the impetus where we can get back to some of what it used to be, and it can be serving those larger roles as well. So all in all, I've really appreciated the testimony. I've learned a lot. I think it's opened up a lot of really good discussion, and I thank you all for your time and what you have each contributed. And I guess I'll just leave it there. Thank you.
Thank you, Senator. Senator Torres, would you like to comment on the bill?
Thank you. I want to thank Mr. Hattori and Mr. Morrison for pointing out that the vulnerable victim definition is already contained in statute, and it is contained along with, in describing vulnerable victims, along with the elderly, our children, disabled citizens, and also victims of multiple assailants. So I think that the statute that you point out is quite generous in including tourists in that vulnerable victims definition. What I'm a little disappointed in, quite honestly, is that the visitor industry would be complacent with increasing the mandatory sentences as opposed to advocating at this point on enforcement. Because I think that Chief Suva, you bring up a very valid point, that when you were describing all the practices and all the infractions that are being committed in Tumon, including loitering and lewdness and all the things that are all the crimes against the tourists right now, what I believe what we should be focusing in is the sentences right now, including all those sentences contemplated under vulnerable victims, already exist. So if that's not working on its face, if you can include a tourist along with an elderly, a child, a disabled person, and a person with multiple assailants, if that isn't enough of a statement of support for the safety of tourists, I think I can't see what more we can do other than enforcing that. And that, I believe, is where the point of discussion needs to be. You can tag on a life sentence to harassing a tourist, and that's not going to prevent, as Mr. Suba indicated quite clearly, those people that are oblivious and probably don't care. But why are we not here talking about what are we going to do to increase the police presence, to deter loiters, public drunkenness on our beaches, those people that stalk tourists coming down, walking from Kmart down to San Vitoris Road? You know, those are the talking points right now, because I believe the laws, as was very clearly pointed out by the public defender, are there. And what concerns me, as my colleague pointed out too when she was talking about vulnerable victims, is what concerns me is what statement are we making to our public right now, that if you commit a crime against a tourist, that is going to be more egregious than a crime against you and I. That is troublesome, because rather than upping the value of the tourists, I think what we need to do is raise not only the consciousness in our community about how we have to act responsibly by enforcing the laws against tourists and others, enforcing the laws, deterring crime by having more of a police presence, more of a consciousness. And actually, GVB does a great job of advocating for the Guam brand and the role of the citizen in promoting the Guam brand and being part of the Guam essence. I think that that's a very valuable campaign. But I think what this does is it sets the tourist on a higher pedestal and perhaps is not compatible to what is our role in the delivery of the tourism experience in Guam. So I'm advocating from the point of view of the citizen, because this would not make me feel better about a tourist. It might make me feel that maybe the tourist is more valued than the rest of us, just by upping it this way. They're already in the vulnerable victim category. That is a great, that is already a huge advantage to tourists in terms of you know, going against people who victimize them. But I would expect really that the point of discussion here is not what haven't we done, in terms of what do we need to do more, what have we not done enough of. I believe that it's not we haven't put in stricter penalties, it's that we haven't enforced our laws. And that really is where I think we should talk. Because it just sends mixed messages, and I get it all. I mean, I was part of the industry, I was part of the branding, I've been a citizen here, I've been paying taxes only to Guam, so I get it all. But I think too that if you're going to get buy-in, this is not the buy-in. This is not going to send the right message. All the other things that you're doing are sending the right messages. The Guam branding, encouraging them, showing people where the tourism dollars affect all of us, showing us that, you know, they're 30% of the 30% of the workforce. If is that correct, or thereabouts? So please comment on that, because that's just my take on the flip side of this bill.
I do agree. Enforcement is the major importance in here, and like I said in the early statement, this does not discriminate the local residents or anything like that. This is a concern to everybody. And as GBB, we are spending whatever we have resource for the destination management. Until 4 years ago, as you recall, Tumon Street was very dark. So we spent our time and effort to light it up. So now we have lights now, but there's certain areas that is still dark. So that is what the Chief Suba said, prevention. You know, if there's a lot of dark places, that make people commit crime. So we're trying to prevent that. So we're trying to light up that whole strip so that all the tourists and the locals can have fun and a safe area to get together. At the same time now, with our new destination, we are setting aside a budget to light up that intersection where the Kmart is. That is very dark, and we all know that, waiting for an accident to happen. And the crosswalk is still not painted enough so that people who is tourists might commit a crime going through a red light, not knowing there's a crosswalk. So this is also, we're not discriminating that this is tourists versus locals or the local residents. This is an effort to help everybody. And because of the the thing is, as a business, as GVB, we need to protect the tourists at the same time as the locals. That's why we are supporting that, and not individual, but entirely as a business model. We do want to make sure that this whole island is safe for both the people who live here and for the tourists. And unfortunately, the tourists, legally, they do get victimized because a lot of people understand that they can get away because they're not going to come back, meaning to press charges or whatever. So these criminals are, some of them are smart. If they can get away with it or if they don't get caught, most likely they won't because according to the tourists, they all look alike, right? So that's why the VSO is always on the street taking pictures or the potential criminals on record so they know if they can show it to the tourists saying, is this the one? And that goes to the locals too. Is this the one that you got stolen at the beach for your purse? That it's a victim is both tourists and the locals. The locals do hang around at the beach and they get victimized too. So we want to make sure that people are safe here. And this goes to everybody. And I really agree to the senator reflecting that this is not only tourists, this is for everybody's problem. And we are here for everybody. Tourism is for everybody, and that goes to, because people coming from Deredo to Tumon, they're tourists. They're touring Tumon. You know, this is their island, they want to have fun. We want to make sure that people at the beach having a safe environment for kids, the elderly, and everybody. And we want to make sure the elderly can cross the street safe, and that is the safety for that we're concerned. Not only for Tumon, but for the entire island. Again, yeah, every place. We're our responsibility for the entire island.
But this is upping the mandatory sentences, or this is upping the
upping,
terms
so
for
that,
just the tourists. And that's the point I'm bringing up.
Right. The detail, I'll leave it up to the legislature, what is proper issue, how to write the legislation. But we're here saying that we're here for the safety for everybody, and we're just supporting that safety is the key to this island.
So you advocate for enforcement? Sir.
Yes, enforcement. That's
my point. This is not going to do anything different tomorrow than it's going to do today unless you enforce.
Yeah, from day one when I joined the GBB, enforcement was always an issue. When we repair something, enforcing that the repair is done properly. Enforcement is the key for everything. So I do agree, Senator. Thank you very much.
Thank you, Senator Torres. Mr. On.
Yeah, you know, we understand, and I hear Senator Torres's points. You know, and I think we also have to think, and it's also going to be fair to say that, you know, enforcement is good. If we build up the enforcement in Tumon, how are the residents in other villages going to feel when we don't build up enforcement there either? So I think it's a two-way street here that we need to discuss. I do agree with a lot of the points that Senator Torres brought up. Enforcement's always key. You know, we just have to make sure that we're fair with enforcement all around the island. If we're going to build up one area, you have to build up the rest. But in light of the legislation from to up the sentencing and the crimes committed against tourists, I'm going back to the testimony of the gentleman before that said he thought that the system was a joke. He just kind of skidded around the whole system and had his way until he had to go to jail at some point where it was severe. 3 years was enough for him to wake up. Hopefully that might help when people can see the severity of their crimes or understand the repercussions that they're going to face if they know that it's going to be very serious. And I think that's something that we support in that manner. Thank you.
Thank you, Mr. Alvarez. I want to reiterate also some of the points made by my colleague that the current law already indicates that the judges have the ability to increase the penalty, from the penalty for theft or robbery, increase that from 5 to 25 years. So whatever that original penalty was, they could increase it by that amount, up to 25 years. Much longer than the person who testified earlier had been incarcerated. And so
Senator, could I
guess the-
mention something when you have
Pardon?
a moment? I just wanted to mention that the difficulties in prosecuting these cases is because these are tourists and they've oftentimes gone home to Korea
Yes,
or
that's-
Japan, and there isn't a witness when the case comes around for trial. So what we've talked about earlier about having better cameras, having a bigger police presence, that would add witnesses, and the case may potentially still be able to go forward regardless of the victim being on island or not. I think that's essentially how this problem would be solved, because the law seems to already protect the people that this bill is seeking to protect.
Thank you very much for making that point. I wanted to point out that I wish the Attorney General was here, or the Guam Police Department formerly was here, because I did want to talk, have that discussion as to, when it comes to tourists, what is the issue with prosecution? So we've seen some successful prosecution, but they've always pointed out that, when victims leaving is a big issue. And so if there's another way that we could address that. In addition, we've seen the increase in presence of the visitor safety officers, thanks to Guam Visitors Bureau, the people of Guam, the hotel industry. We've also seen, we've put resources of the government into a Tumon precinct. GVB's put resources into different types of items, such as the lights, the cameras, the just clearing. I know they've even done clearing of. They've pointed out in previous hearings here at the legislature hotspots that they thought where crime was happening according to their statistics, and that needed to be addressed together with the police department and together with private business owners. And those were hotspots for crime against tourists. And so I agree that we need to continue to focus on this. We all want to protect our industry as much as we want to protect the people in the villages. And so I see Tumon, at least for me, I just see it as if putting all these resources into Tumon, I hope will give us a pattern of what we can use in the rest of the island. So we could use it as a model, and not that we stop there by any means, and that we can get from you all who are doing the work. And I see some GVB employees here who are actually the ones who deal with the tourists who have been victimized. So thank you for being here. But I want to learn from that and move and grow that. So grow that, make it. We still have crime in Tumon despite all the resources we're putting in there, and that's unfortunate, and that's the problem. So how do we make that better? How do we increase the enforcement? How do we bring that out to the other villages just as much as we did for Tumon? Yeah. Chief.
Yeah, please don't get me wrong. I am all for increasing penalties, however it can be brought out, and if it's there, it's there. But I'm really appreciative that this body has brought things to light in just discussing the fact that something has to be done. And although it's already on paper and it's been proven to exist, it still remains that there has to be things to address those other areas, and the enforcement of, obviously, whether you raise the minimums or you don't, all of these things come together, and that's why I was saying it's multi-pronged. But I truly and sincerely appreciate today's hearing. I wouldn't have come out if I didn't feel it was so important as GVB does. So thank you.
While we're here, I'd like to just give some praise to Guam Police Department for the recent, we've all seen the video, and the sponsor of this bill wanted to play that video today, but I told him we had all seen it on the news already, and to save some time, so my apologies. But it is, it moves us all. It's horrendous. But we've also heard the news that Guam Police Department quickly apprehended them. So I wanted to just thank them for that work. And again, we've heard the news from Guam Visitors Bureau that during Golden Week, there were no incidences of crime. They increased all kinds of things down there at the airports, and I want to praise all of you. And so we've got some good programs, and I think we are learning how to deal with these things, how to stop, fixing one area, and then the crime just comes right back in. So hopefully we can, we can expand on these. And so I just wanted to thank the employees of GVB that deal with these victims. I know you work closely with the consulates offices also, and that they're instrumental in the messages that they are getting out. And so we have to all work together. So I'm happy to do our part here. And Senator Tite, we had one more question.
Actually, Madam Chair, everything that was discussed about is exactly what I wrote down, and I'm, with regards to the witnesses and the victims coming here to testify. Now, I do know that probably a lot of these individuals who are committing these crimes think they can get away. I mean, I think I heard it from someone who said that because they think they can get away with it. But I know that GVB, you have a Korean department, you have a Japan department, China department within GVB, and funding that's issued toward that. If there's any possibility, I mean, and the good senator mentioned the consulate generals who I've worked with before, to bring back these individuals, because sometimes it costs the victim to come back for the trial. And if they can't do it through deposition, and testimony via, electronic, Skype or anything like that, if it's not acceptable, then the possibility is to have GVB bring the victim back to ensure this and have a practice of doing that. Maybe that would deter. It's just an idea, but I'd hope you bring it back, Milton, to the board to discuss this. Okay? Thank you.
Thank you, Senator. I also wanted to just add for the record that we had researched, and the U.S. Department of Justice Office of Community Oriented Policing Services issued a Crimes Against Tourists Guide, updated. The one I'm looking at is not updated since 2004, but it does list 11 specific responses to reduce crimes against tourists. And very quickly, I just want to read these because I think we've done several of these. And working with the tourism industry to identify and address crime-related concerns, training police and private security staff to recognize and address tourist-related safety concerns, facilitating tourist victims' testimony in criminal cases. Legislation provides funding for victims' travel expenses or for equipment for them to testify via teleconferencing. That's one of their recommendations. Imposing additional taxes in tourist areas to support special security measures. I think we have done this by putting a precinct down there and many of the other measures of VSO officers in this area. Encouraging hotels and motels to adopt practices that will reduce guest victimization. That includes the cameras and working with the personnel to install other equipment. Offering rewards for information leading to arrest and conviction of those who commit serious crimes against tourists. And educating tourists to reduce their risk of victimization. Increasing uniform patrols in tourist areas. Deploying citizen patrols to supplement police patrols. We've done that. Conducting surveillance at high-risk locations, and I want to thank GVB for pointing out the high-risk locations. I think that's one thing I'm very happy that they've done a very good job about that. They're keeping statistics. That I think is going to lead to action. Changing the physical environment to reduce opportunities for tourist crimes, and that's the action. So again, thank you for your testimony. Before I give to the sponsor to conclude, I would like to point out that we've also received written testimony from Candida Guzman in support of the bill. Thank you. And that will be included in the record. So, Senator Moylan, you may close on the bill.
Thank you, Madam Chair. Appreciate all the testimony, and I'm sure as we move forward to trying to help our tourism, protect our tourism and our citizens, that even though the tourists are not here, there's got to be some way, and this is helping us look into solutions where technology does help, where they can't come back, but they could have an attorney present with them over there, and we can do something. I'm sure there's something else we can do. And at the same time, we hear the stories about we want to improve our rehabilitation process, and of course we have to, because the majority of the prisoners will be released, and we know we need more police enforcement as well. The common denominator, it all takes money. And tourism is a major economic engine for our island's economy. And any crime committed against our tourists is more than a crime against an innocent victim, but it's also a crime against our community. The tourism industry employs over 20,000 island residents and represents a significant percentage of Guam's gross domestic product. So whenever a crime is committed against one of our visitors, it, as you mentioned, sir, it creates a spiral effect that spreads when the individual returns home and shares their horrific stories with family and friends. Any adverse brunt affects tourism, ultimately impacts our economy, our community in an adverse manner. And as an island community, we take pride in our hospitality and our industry. We have many professional people out there, and they have very many professionals that have greatly invested in many aspects. And that we have to protect our island, its global image, as you were mentioning, sir, and our people, of course, and of course our guests. But Guam needs to create a stringent policy, reminding everyone that criminal activity against visitors is not to be tolerated, and only the maximum penalties should be imposed in the event one is convicted of any offense against and crime against tourists. This is not only vital for the sake of public safety, but also for the intent of preserving our economic engine. So I thank you, panel, and I thank you, Madam Chair.
Thank you very much, Senator Moylan. And thank you again to the panel, Sizus Masi, to all of you who have been here waiting for this public hearing. We will now move on to the sixth agenda item for this public hearing, which is Bill number 160. It is 4:24 p.m. Senator Moylan, you may introduce Bill number 160-35.
Thank you, Madam Chair. Bill 16035 is an act to amend subsection 40.15E, 1, 2, 3, 4, and 5, and to amend subsection 40.20C, all of Chapter 40, Title 8, Guam Code Annotated, relative to pretrial release for those charged with crimes associated with criminal sexual conduct, robbery, kidnapping, and distribution of possession of a controlled substance, and mandated electronic devices for bail conditions of certain crimes. Bill 16035 addresses a common occurrence we are seeing within the judicial system where judges release defendants on personal reconnaissance while they await trial. While we recognize this as a part of the legal process, one too many times we see one on pretrial release commit another crime, as we earlier heard. The legislation creates additional barriers for those being charged with crimes such as criminal sexual conduct, armed robbery, and distribution or possession of controlled substance, that their only qualified form of pretrial release is via bail process. There are those who state that this legislation creates an unfair advantage for those who don't have financial means to post bail or obtain a good attorney. The reality is that as a government, what do we tell the victim of a sexual assault or one who had a gun pointed to their head that they don't have to allow this perpetrator to be out on bail while they wait trial, since they can't afford bail? We look forward, Madam Chair, for a healthy discussion on this issue. Thank you.
Thank you very much, Senator Moylan. I'd like to state for the record that the committees requested the feedback of the Attorney General, the Judiciary, the Guam Police Department, Child Protective Services, Victims Advocates Reaching Out, the Guam Coalition Against Sexual Assault, the Public Defender's Office, the Guam Bar Association, and the other stakeholders. We've received a fiscal note from BBMR stating that this bill is administrative in nature and therefore has no impact on the finances of the government of Guam. Just a minute. It says here that the Legal Bureau's recommendations are pending, and those might have come in right before this hearing, so I haven't reviewed them yet. The electronic monitoring, we said, I do not have an update from the court as to the implementation of their electronic monitoring system at this time. I would note that the bill requires that limits or prohibits release on your own recognizance for these certain crimes, including possession of controlled substances, and it requires the use of an electronic monitoring if you are released, and it also says that the defendant must pay for the electronic monitoring, and so that, I guess, is how the BBMR came up with no fiscal impact. We did a very quick summary of, well, I'm not gonna go. I was trying to collect data on how many people this would be affecting, but I don't have those numbers at this time. So, Attorney Morrison, if you'd like to testify on this bill.
Thank you, Senator. I spoke to Director Ettore about this, and it would be his intention to file a written testimony for this bill, but that has not occurred yet, so I think the committee could look for him to supplement the record with that. I would say, though, for today's purposes, that in my view, this would result in an incredible uptick in the amount of people that are currently incarcerated at DOC waiting trial, particularly in its broad sweeping nature that it includes people charged with possession of a controlled substance. Even as a first-time offender, as I read it, are going to have to wait until electronic monitoring is approved and they have the ability to pay for it. I think that pretty much covers all of my clients. I don't think that most of them are going to be able to come up with the immediate means to pay for their own electronic monitoring. The requirements as they currently sit for electronic monitoring require someone to get a landline telephone, and sadly even that condition is beyond the means of many of the clients that my agency represents. They're unable to qualify for the program because of the lack of $200 or so to get a landline installed. So I believe that this is going to result in the mass incarceration of a lot of people that haven't been proven guilty of anything yet. I would also say I'm concerned about the constitutionality of the bill, given the price. Some people may be able to bail out because they have the means. Other people are going to have to wait, stay incarcerated because they don't. I know there's some litigation currently going on in Arizona. We'll submit that along with our written testimony, but it seems that similar legislation is currently under attack for those reasons because of the cost of placing the cost of doing it on the defendant. So I don't believe that the bill is purely administrative in nature. I think this is going to just result in a huge increase at the Department of Corrections that's going to have to be paid for. I would also say I can't speak for the court system, but we currently have a drug court that many first-time offenders do qualify for. It's something that my agency attempts to act very quickly on. When we get someone that's a first-time offender, it looks as though the police report says what it purports to say. We try to get them into that program so they can get help immediately. I view this as something that would delay their getting help because they would then have to be evaluated by a probation officer while they're in custody. It's much more difficult than being able to schedule it and make the appointments themselves. So I have some concerns about it in that regard, that it's potentially unconstitutional, and I think is going to result in a lot of incarcerations of people that don't need to be incarcerated waiting to get into a program or have their case disposed of otherwise. Those are my comments on that. I'd be happy to take any questions.
Thank you very much, Attorney Morrison. I want to add that I do have the Legal Bureau reviews, Legal Bureau's review, and they do also suggest that there are constitutional issues that have to be addressed, including potential unreasonable search in violation of the Fourth Amendment by requiring this device, attaching a device to a person's body without consent for the purpose of tracking that individual's movements in certain circumstances. And so they do a thorough review of some of the cases, and they say, taken together, these cases appear to suggest that blanket statutes requiring electronic monitoring may constitute unreasonable searches. And in light of the U.S. Supreme Court's decision in Grady and other state cases, the committee should consider further examining potential constitutional search and seizure issues raised by the proposed legislation prior to the body's final consideration of the bill. And I think this is all because it's well, I'm going to verify if it's because it's pre-trial release or otherwise. But I thank you for the points that you've made. I think those are very, very pertinent. And so are there any questions from the panel? Senator Torres? Senator Rigel? Senator Taitigui? Senator Kelly Marsh Taitino?
I believe we went over some of this information about electronic monitoring devices, but it's been a while, and I don't know if you have the information readily on hand, but I'll go ahead and ask and
Sure.
see. So you had mentioned that with the phones, that even that is out of the reach of a lot of your clients, and you had mentioned a $200 cost. Do you have an understanding of what the cost would be for an electronic monitoring device, roundabout?
I'm not sure what it would currently be set at. The pilot program, I believe, is already funded, so I'm not sure if those costs are being absorbed on defendants at this point. I don't have any additional information from you for you at this point, but in other jurisdictions, I recall hearing numbers like $50 a week or something like that in other jurisdictions I practiced. So the costs, while I think it would be a no-brainer for most people to pay $50 to be out of jail every week, for people that are just completely without the means to do that, it just means that they're going to stay in jail.
Right, and if this is going to potentially have a great intake, I mean, we would have to consider having maybe a rather sizable inventory of these electronic monitoring devices on hand, so that we could accommodate the ebbs and flows of the situations. And we all know, well, things have gotten better about getting things here on Guam. We can get things within a week or two, whereas when I was growing up, it was 3 months or more. But certainly it seems it would take a sizable investment, some logistics involved to have the inventory. And so I had wanted to, at the very least, just have a better understanding of that. And I'm sure it won't be difficult for me to look up the costs of the electronic monitoring devices or ask those involved in the pilot program. The other, now, I prepared this late at night, so hopefully it still makes sense. As I was reading through all these bills yesterday and so forth. So it seemed like with this new section that it has this notwithstanding any other provisions, and it says that they will not qualify for the release on their own recognizance. And above it, there is the ability for the judge to be able to assess based on history and characteristics, the length of his or her residence on Guam, his or her employment status and financial condition and so forth. So there was a lot of ability to be able to assess all of those considerations. But in these new situations, or this new section here, it looks like that's going to be removed. Have you found that there have been issues with the judge being able to have that flexibility in A through I, being able to look at the history and the characteristic to help them ascertain or calculate? If
Those look like pretty standard provisions that the judge would consider. However, I want to be clear here, in the majority of very serious cases, the person simply isn't released on their own recognizance with no further condition. Oftentimes what will happen is someone is appointed to a third-party custodian or custodians, and they're allowed to be released on their own recognizance, meaning they didn't have to post money as long as they're with this person or people, or at least one of them, day and night. So I think I can rest on that essentially. I just want to be clear that own recognizance doesn't mean without any other conditions, that those are oftentimes in place as well as curfews. And those are things that may lack a statute, but are conditions that the judges impose.
That's very helpful for me to hear, and it provides me context. I'm not as familiar with that landscape, and so it does provide what I feel is important information in being able to assess this situation. Situas Masi for your answers.
Thank you, Senator. Any other questions? Senator Moylan, you may close.
Thank you, Madam Chair. We've heard the cries of the community, and just as many of, and even today, we're hearing more testimonies about comments about the pretrial releases, and we've read many media stories, and it's all disturbing to see individuals committing crime while on pre-releases. And concerning when a person is charged with a serious crime such as rape or armed robbery to get released on personal reconnaissance. And if the government is truly to address the rising concerns of crime in our community, an array of approaches need to be reviewed for stringent sentencing, increased presence of police officers, of course, and even how pretrial is administered is critical in the terms of keeping our community safe. So thank you, Mr. Morrison, for spending the day with us. I really appreciate it.
It's my pleasure, committee members. Thank you very much.
Yeah. And thank you, Madam Chair.
Thank you, Senator Moylan, and thank you again, Attorney Morrison. We have one final agenda item. Well, I want to note that it's now 4:40 p.m., and we're going to move on. We're going to move back to the fourth agenda item that we temporarily skipped over. And we have how many minutes? 15 minutes. I think we can conclude within the 15 minutes that we have left according to audio, so we're going to continue. So on Bill, Senator Moylan, you may introduce the bill. Fourth agenda item, Bill number 143-35.
Thank you, Madam Chair. It's an act to amend subsection 34.20, 3430, 3450, and 3460, all of Chapter 34, Title 9, Guam Code Annotated, relative to penalties established for aggravated arson, negligent burning, and criminal mischief. This legislation modernizes Chapters 34 of Title 9, Guam Code Annotated, when it comes to penalties associated with arson, negligent burning, and criminal mischief. Not only does it stiffen the penalties, but it also recognizes work credit programs for those sentenced for such crimes, and even places some civil liabilities on parents or guardians of minor children who are charged with the crime. Bill 143 addresses crimes that destroy property and are issues that we unfortunately are seeing more and more in the media reports. Yes, we need greater law enforcement presence in the villages to deter crime. But at the same time, a stronger message needs to be sent to those who commit these crimes, that enough is enough. We also need to be tougher on juveniles who commit these crimes. And this includes holding them responsible and accountable for their acts. Thank you, Madam Chair. I look forward if there's any healthy discussion on this issue.
Thank you, Senator Moylan. On this bill, we have received a fiscal note, and the fiscal note states that besides the additional monetary penalties imposed by the proposed legislation for the commission of the specific criminal acts, the potential fiscal impact of the bill would be on the appropriate resources required for enforcement of these mandates, prosecution of those charged in judicial proceedings, all incarceration of convicted individuals detained at DOC, etc. Such costs may be offset by reduced sentences resulting from provisions in the proposed legislation. However, absent additional information from the Office of the Attorney General, the overall fiscal impact cannot be determined at this time. We also have recommendations by the Legal Bureau. which include, relative to the legislative intent section, where it references a work credit program established by prior public law, and other sections throughout the bill, amend 9 GCA Chapter 34 to authorize work credit. If the intent is to reference a particular public law, then that public law should be cited. Otherwise, if the reference is to a bill that has not been enacted, then the reference should be deleted in the legislative intent. All right, any comments or questions from my colleague? Senator Taitigui?
Thank you, Madam Chair. I was hoping that Director Ishizaki was still here to just ask him how active is the work credit program and how many individuals have participated in the work credit program. So there was an invitation to him, Madam Chair, to participate?
Absolutely. We've extended invitation to all the parties that I mentioned earlier and at the beginning of the hearing, AG, Public Defender, the Victims Advocates Units, and so forth.
Okay, thank you, Madam Chair. And I just hope that if he's listening, that he would provide that, his testimony. Thank you so much.
Thank you. Any other senator have any questions or comments for this bill? No? All right. I would just like to state. All right, Senator Moylan, would you like to close on this bill?
Yes, thank you, Madam Chair. Bill 14335, other than stiffening the monetary penalties that are noted in the criminal acts, the legislation would allow adult offenders to qualify for work credit programs, establish a prior public, the legislation would also allow adult offenders that do qualify the work credit program established in a prior public law, thus giving them the opportunities to further give back to the community and earn credits for a reduced sentence. The intent of the legislation is to focus more on establishing lessons versus extending lengths of crimes. And these lessons, it can be instituted among the juvenile offenders, then opportunities to instill positive and optimism for these minors will be beneficial for both the individual and the community. Thank you, Madam Chair.
Thank you very much, Senator Moylan. Before we conclude this hearing, I would just like to thank Senator Rigel for this time slot that we've had from 1 through 5. If you're wondering why I crammed all these bills in this afternoon, it's because it's very difficult to get time slots for public hearings in the session hall during working hours when we wanted the Attorney General and the Public Defender present. So I appreciate them taking the time. So Senator Rigel, thank you for the slot for today. And thank you to senators. I know this is long, and I thank you for sitting here with me. We have received some excellent testimony, and I hope that will make our measures improved. So there being no additional testimony, this committee will continue to remain open until January. Well, I'm going to strike that. We will remain open for testimony until the end of the day tomorrow, 5 p.m. You may send it to my office or to Senator Terlaje @gmail.com. Si Diyos maasi for all your testimony, and the public hearing is now adjourned. The time is 4:45 p.m. Si Diyos maasi to audio. Si Diyos maasi.